It's 2 o'clock, and we're calling the Code Board meeting to order. Bobby, would you call the roll, please?
Ms. Wade?
Here.
Here. Mr. Weeks?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Ms. Norfleet?
Here.
Ms. Telliar?
Here.
Mr. Porfirio?
Here.
Thank you. Mrs. Vacacy? Absent. Please, your roll call.
Thank you. If you'd please stand, we'll have an invocation and pledge of allegiance.
Father, we seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is in the best interest of the city of Tarpon Springs. This we pray. Amen.
Amen.
I pledge allegiance to
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm going to explain the procedures of the way the meeting works. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order to this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. And here's the procedure of the board. First, the city presents its witnesses and exhibits, after which the violator is able to ask questions of in any specific questions regarding the testimony. Secondly, the violator, the alleged violator, is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and the part of the alleged violator, each party is asked to give a closing statement, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss and take appropriate action. Before we begin public hearings, we'll have all potential witnesses stand up and be sworn in by the secretary of the board. You're going to speak. Please stand up now.
Just a moment. Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. Please be seated.
Just as a reminder, have everyone please turn off your cell phones or silence your cell phones. There are a couple of changes to the agenda to accommodate those who have come. Item number 1 will be item number 10. Item number 2 is listed as 11. Item number 3 is listed as 4. Item number 4 is listed as 2. Item 5 we have shown as 12. And item 6 will be what's listed as number 5. This is to accommodate those in attendance who wish to be heard before the board in regard to their case. And that's why we've modified the regular agenda to hear the following cases in the order that they came. We're going to begin with new business, and I'm going to ask the city's going to present its case. This is item number 19-80000 806, 713 Dodecanese Boulevard, Joyce Pappas, Venitza Living Trust, Venitza Meehan, Theodosius Venitsas. And this is in violation of code APPB, outdoor displays, and it has now in compliance. Would you like to present?
And there's people here for it.
Would you have this, if this is your case, please come forward to the table. Thank you. There's a microphone there, and we have trouble hearing if you don't speak right into it, so y'all pull it up, please.
All right.
So the officer will present his case, then you can ask questions, then you can present yours. There we go.
They were presented with the evidence packet as well.
Get that.
So, any objections? Herbert, any objections to the evidence being submitted by the city?
All right, there's no objection, so if you'd like to present, thank you.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case before the board is case 19-800000806. The address is 713 Dodecanese Boulevard. You covered the ownership of it. This is a repeat violator case that is currently in compliance. It stems from two prior cases. Those case numbers are 17-800000053 for the same city ordinances, Appendix B, Chapter 6. That case was established. There was no fines associated with that case. The second case is a 2018 case, -8000396. Same city ordinances, outdoor display. At that time, they were fined $10 per day. That fine has been paid. Exhibit number 1, going before the board, all of my photographs. Exhibit number 2, all my notices to include notice of violation and notice of hearing. Exhibit number 3, administrative documents, case summary, previous board orders, property appraiser and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign, and exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits are given to the violator. Exact copies was what's being presented to the board. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt as well as first-class mail. And Madam Chairman, please accept these exhibits into the record as evidence.
Barbara, you do that, please?
Yes. Yes, ma'am.
Thank you. We have had contact with the owner and the tenant. My case started originally on November 8th of this year. I was working an off-duty detail down on the sponge docks. I happened to notice at 713 Dodecanese, which is on the south side of Dodecanese. It's a retail establishment, that they had numerous items hanging from their doors. They had racks with displays greater than 36 inches in height, and there was less than 24 inches, but the code's actually 18 inches of clear space on the interior of the doors, which is a violation of the Smart Code Appendix B, Chapter 6 for outdoor displays. At that time, on November 12th, the repeat violator notice of hearing was mailed. The green card was returned signed by the property owner. On November 22nd, I conducted a reinspection at the request of the tenants, and they were still not in compliance. There were still displays blocking the door, and there were racks above 3 feet. Conducted another inspection on December 2nd, and it's still not in compliance, and I added photos from that case as well. We had conversation with them in the office, so I conducted another inspection on December 3rd, which is where they were in compliance. Originally, this case was supposed to go last month, but it was deferred at their request, so we're here now. I posted the property on December 27th, and the interesting thing is we show them out of compliance from November 8th to December 3rd. The thing that you have to consider is they close every night. So in reality, it's kind of like everything's taken inside and the business is closed. So on the occasions that I've gone by during the day, it's been in violation again. So it's an interesting scenario. I saw it 3 times out of violation during that period. So I just want the board to be aware that there are 3 specific dates that I saw it out of compliance in that time period. I don't work at night, so I don't see it at night. I just know that there's no businesses open at 11 o'clock at night. So just for the board's consideration, there are 3 days where I saw it out of compliance, and you can see that in the photographs. And then I put it in compliance on the 3rd. But there was a period of time from when I first saw it, November 8th, and when I finally saw it during daytime hours was on December 3rd of last year. So I just want you guys to be aware of that so you can understand. It's a unique situation with the businesses down on the docks. So that's all I have at this point in time.
Board members, do you have any questions for the officer?
You said December 3rd was the last time that you saw it out of compliance?
December 2nd was the last time I saw it. We had contact with her, and she took care of it. I came back out the next day, and it was in compliance on December 3rd, during business hours. So,
Do you have any questions for the officer?
Yes, I do.
Just questions at this point.
Yes, thank you. Herb Elliott. I'm a local attorney here for the alleged violator. Officer, looking at the agenda this afternoon, I just see one other.
This would be a time for questions.
Yeah, I'm questioning. I'm going to lay a little predicate, and I will ask a question in a second if I could. Okay. I just see one other violation of the sponge docks. Is it fair to say that these are the only 2 current citations for this kind of violation at the sponge docks?
actually, there's none currently. They're all in compliance.
But there's no other pending violations?
That's correct.
Thank you. And then also in the backup, I see no reference to the actual ordinance violations for the SMART code or the ADA or whatever you said. You've done a great job of giving the ordinance to the alleged violator for portions of the city code, but I don't see anything in the backup given to the alleged violator, rather, as to the 18 inches of free clearance in the doorway. Is that correct?
I don't have what she received, so I would have to see that in order to answer that question.
You do not have your backup?
I see a different version than what's mailed to the violator.
Or well, I'll make this case when we get to our
I think that's
side
going
of
to
the
get it
story.
for me, so. I can tell you this much, Herb, the SMART code's pretty thick. That's why we reference one section of it, and there's also a link to the Muni code in the violation.
But
hang
the
on,
actual-
Give me just a second, and we're pulling up what was sent to her.
But the actual texting of the citation of the actual text is not in the violation, unlike for the city land development code, correct?
That very well may be correct, because we do send out, what typically happens with our system is once that code's put in, it actually prints out the ordinance that's applicable to that and should go with them. We don't keep an exact copy of that because we have it online.
Well, why do you?
But there is specific violation text in the letter that was sent that stated, violation text under Appendix B, Chapter 6, Outdoor D, it says, outdoor display violations, items hung from doors, less than 24 inches from clearance from the doors, racks with displays greater than 36 inches in height. That was the actual violation cited.
But there's nothing in the actual violation detail that I see that references the 18 inches that has to be a clearance on the inside of the store.
Under which one? Because there's 2 violations. There's the Appendix B6 outdoor, and then there's the one where we just adopt the SMART code. That's a city code that we just have to apply that says we're going to use the SMART code.
Does the board understand my question? The backup that you have, I believe, ordinance description, Appendix B, SMART code adopted, that's all it says as far as the violation. Unlike the other allegations on the first page, Appendix B, Chapter 6 definitions, there's a specific citation of the wording for Section 1, 2, and 3, and 4, and 5.
He doesn't need to ask you questions. You cross-examination, Herb.
Okay, all right.
So I can answer that. Certain codes, we have to adopt other things. So what we do is we are just informing the violator that in order for me to use the SMART code, there was an ordinance enacted by the city that says, hey, we're going to adopt the SMART code. So Appendix B SMART code adopted, it's not a violation per se, it's more procedural, just saying, this is the authority I'm using to cite under Appendix B, Chapter 6 of the Smart Code.
All right, thank you. So is it fair to say then you've given the alleged violator the actual wording of part and only part of the alleged violation? The part referencing the smart code does not give the specific violation, just a generic reference to Appendix B, smart code adopted, without telling them what the actual violation is.
Because the adoption of the Smart Code is just saying on the previous violation that I have the violation text, those are the specifics that are in that chapter that they violated. Having displays over 36 inches, blocking the doorways, and hanging items from the door. That's specifically defined in the Smart Code, Chapter 6, Appendix B.
All right, I'll stop my cross-examination at that point, and my client will explain a little further what the problem is. Thank you. That's all the cross-examination I have.
I'm sorry I didn't ask for your name as you were seated there.
Gloria Krutzik, K-R-U-T-Z-I-K.
In your relationship to the property,
I own the business inside, not the property. I run the business that's operating in the property, on the property.
So you're the tenant, correct?
Yeah, tenant.
Okay.
she owns the business but not the property. Is the property side of the business?
Yeah, I believe the owner is also here.
Yes,
The owner's here.
they are here, yeah.
It's okay.
All righty. If you'd like to present your case, please.
Yeah,
Okay, state your name and
my name is Gloria Krutzig. I own the businesses in the two stores that's in violation here. And I appreciate you listening to me because at one time I was out, I broke my kneecap, and some of the stores were putting out things when I wasn't there, and the officer brought it to my attention. And we thought we went into code the very next day.
code compliance.
Yes, code compliance. And we actually then got another notice saying we weren't in, so we went down to this code office and spoke to the lady that was there. I believe she's here. And she explained it was about the inside of the store, which we didn't know. Last time there was any questions, the racks that were in violation this time were in the same place they were then, and that nobody said anything about them. So we weren't aware that that was the violation that they were talking about, the inside of the store. And I agree, there may have been a rack that had been about an inch too high. We sawed it off and made it be in compliance. And so we really attempted the very next day we got the notice to be in compliance. We were just in confusion, and we all went down to the office, and then the lady tried to explain about this code that he's speaking about, which we didn't know anything about, that you couldn't have this rack inside the store where it was. And then we got in compliance because we moved that. And I don't know if this is the time or place, but our only thing about this is that there are other people down there. Their racks are higher than mine. I have pictures to show it. They're right up next to the door. They're not
Objection to
18
relevance.
inches. You know, so that was,
This is only about your case for now. Thank you.
I would disagree. I believe I'm going to cite the board some legal authorization for the fact that if there is selective enforcement of this ordinance, you're entitled to consider that some people on the sponge docks, for example, are in fact in violation of the same code and have not been cited. And we think that's unfair, and I wanted to bring that to your attention. We have pictures which my client can bring into evidence at this time if I could.
Thank you.
All right, do you have those pictures?
yes.
No,
And I would-
hold on a second.
Wait, these will only be pictures of your store. That's the only case we're seeing. And it's like saying somebody else was speeding, so I'm speeding too. So it's not relevant. If you wish to make a complaint against
Well-
another business, you're welcome to make a complaint through the code office.
All right, hold on a second. Hold on a second. Okay, we need to bring it back to what we're talking about here today. They've made a statement, there was an objection, you need to rule on the objection. He objected that they're talking about something that's not relevant to this case. If you're sustaining an objection, we're going to stop any further testimony.
Objection sustained.
Thank you.
Well, I'd like to be heard on that issue, if I
You were
could.
heard, Herb.
No, I haven't given my authority yet.
Go ahead and give your authority.
Okay. Can we pass this down, please?
This document that you're submitting is,
is a portion of a court case that I'm just going to cite for the record. Yeah, there's 7 or 8 copies, I believe. And I'll give the whole thing to Mr. Trask, please.
Is this just a case, or,
Yes.
okay. Do you have the whole thing or just a half the case?
No, I have the whole thing here.
Did you give them the whole case?
Okay.
Yeah.
Could you give this to Mr. Trask, please? For the record, it's Florida DOT versus E.T. Legg and Company, a case from the 4th District, 1984. And I highlighted this one section for the board to look at. We hold that whether there was selective enforcement was a question of fact to be determined by the trier of fact. That's the Code Enforcement Board. And there is competent substantial evidence in the record to support the ruling of the trial court. Once a state accords its citizens a right, it must accord it to all without invidious discrimination or run afoul of the Equal Protection Clause. Further, the court held in another case, a selectively enforced ordinance is an invalid exercise of the police power. It's our position that we've got photographs of many other stores at the Sponge Docks that have been operating the exact same way, and the officer testified there's nothing pending at this time against anybody else. And I think that that is selective enforcement. It bothers me that some people are being treated unfairly. Police officers do a fine job, and I have no problem with the fact that there is a violation. But I do have a problem with the fact that other people are in violation, and they're not being cited. And my client can testify, both of them, they're both here, that they've seen these same violations for months or years without a citation being issued. So it's our position then that we are entitled by law to show you that this is in fact selective enforcement.
And I don't know if I can make a statement or.
He gets to respond.
Well, looking at this case, it regards City versus Lake Wales. It deals with advertising, which is a well-known fact that on-site and off-site signs became a Supreme Court issue. We're not talking about signage. We're talking about the smart code that was adopted by the city code. Also, after your case, there's another outdoor display case at 793 Dodecanese, so that would not be just your client. That is a second business. I have cited upwards of about 8 businesses down on the Sponge Docks for the same violations. So I would ask you one question. I saw the violation on November 8th at approximately 6 o'clock at night. Do they have photographs of any violations at that time? And
Just as a proffer, my clients took some pictures yesterday afternoon of several stores at the Sponge Docks with the exact same problem.
And then I would object to those because they're not relevant, because we dealt with the case on November 8th as the time. This also, the case law that was presented, as I stated, dealt with signs. It's not, I would object that it's not the same situation. I would also offer, most of this code board's been here when I did other cases of outdoor displays on the Sponge Docks. So I think that kind of negates the selective enforcement argument as far as that goes. This particular violator is a repeat violator, so that's why we're here. This is now the 3rd time with this violator. So again, I would present to the board that this isn't the first time she's been here. This is not the first time I've presented an outdoor display case. And this case presented by council is revolving around signage, and this is not the same in that regards. And there is a Supreme Court case regarding that most of us are well aware of.
With all respect, this case has nothing to do with signs. We're talking about general principles of selective enforcement. And my clients are prepared to testify that these alleged violations of the Sponge Docks have been going on continuously for months, aside from the photographs taken yesterday. And I ask that the trier of fact consider these other facts, either from the photographs or from my client's oral testimony, that they're being unfairly singled out as a violator of the city code.
Okay, so we're going to bring it back then. So we're still talking about the objection. They're talking about matters that the city believes is irrelevant. They've objected. You sustain the objection. The question is after this additional information, are you still sustaining the objection, or are you going to overrule the objection? Yeah.
And Beth does have, I have no objection to this being entered, so if you want to present it.
It doesn't need to be entered into
Okay.
evidence. It's argument that is making, it'll be considered.
Understood.
I've made copies for the board to look at this.
It doesn't
It's
matter.
not,
Okay.
it's not
It's not the
admitted as
board.
evidence yet. I
Not
need to read it to
evidence,
rule on
it's
that.
legal argument, that's,
The chairman makes the decision, Herb, it's not the board.
I'm going to sustain the city's argument regarding whether this is relative to this case. So we will not admit this into evidence.
Okay, well, we're going to go ahead and hang on to that. That'll be part of the case. If you want to hand it
I'll
down to
pass
Bobby.
it down to Bobby. It will be included in the information.
Okay, so we're back now to the presentation of the case by the alleged violator.
okay. Anything else you want to say? Let him.
Hold on a second. Do you have any, we're going to do cross-examination, Herb. If there's any cross-examination, do you have any questions of this witness? It looks like they're
I do.
changing witnesses.
Briefly.
Okay.
Gloria,
We'll-
you've met
he'll
me
ask
before,
you
correct?
questions, Then we'll get to your other people.
Yes, I have.
Okay. Did I ever bring you down a packet, 3 pieces of paper discussing the outdoor display code?
No.
I never did?
No,
Did
you
we
didn't.
put up blue masking tape outside of one of your businesses to show
Yeah,
the display?
you
We did
did,
do
and when we
that. So I did
responded.
talk to you about that.
You
We
did
put the-
talk to me,
Okay,
yes, and I
so-
did go down to the board, met this lady that's here.
Okay, so you don't recall, and I know that the board hasn't seen this 3-page document that we put together that has measurements and things like that, although I handed it to you on 2 different occasions, you don't recall that?
Well, I have the code thing you sent, yes, but it just didn't say inside the store. We fixed everything outside, and that's why we were so shocked that there was
Okay.
something the next day. And that was at Seaside, and we had done that before. We didn't know that was in violation.
So when you talk about inside, do you know what the violation is, what you say inside the store?
Yes, I know now
What is
what
that?
it is. Well, it has to be 18 inches so that, from the doorways, inside and outside, not just
18, the doorway has to be clear.
Yeah,
It's
clear,
not.
right.
It's not into your store.
Yeah.
It's the width of the doorway. It has to be 18, and you understand
Yeah,
that?
which our doors were, but they said it couldn't
Okay.
be there at all.
But-
We have double doors.
You also understand the 36 inches outside, correct?
Yes,
Because we
uh-huh.
put the tape up.
Yes, we
Okay.
did. You put the tape up, yeah.
Okay, so, all
Which
right,
we
that's
did,
all I
and like
have.
I said, there was one about this much too high, and we sawed that off.
Okay, so, like in the picture up here, that's your store, right?
Yes, uh-huh.
Okay, so you see all this display over here on, where's my little green laser? All this,
Yes, uh-huh.
and you understand hanging from the door?
Yes, we
which is
did.
part
I
of
knew
it.
that
Okay.
all, yeah.
So that was what your violations were for. I just want to make sure you understand it. We discussed that, correct?
Okay, yes, we did.
Okay.
And, you know, and when
That's
we
all I
went-
have.
We went
Thank you.
down to the board that day, because then we got another letter saying we weren't in, right? And then she explained it was because of the inside rack,
Can you redirect, Mr. Elliott?
side the door.
It's a very slow
Yes.
computer.
All right, Mrs. Krutzik, the city's documentation, looking at exhibit number 2, the violation text, outdoor display violations, you're aware of that, right? Items hung from the doors, you knew about
Aware of
that.
that, yeah.
Less than 24 inches of clearance from the doors, you knew about that. Racks with displays greater than 36 inches in height. Nothing in there about 18 inches from the doors, correct?
Not inside, no.
And you took care of all these problems right away, the
Yes.
next day?
Yes,
The 4 that are listed here?
yes.
No further questions.
Thank you. Next witness?
Mr. Krutzik, you want to say anything? She just has pictures, right?
They don't want to look at them, so you can't look at them.
We're stringing you along.
Okay, this is one of the owners of the real estate. She just had a comment to make. And I'm not her attorney, but you're welcome.
Hello.
Good afternoon. Could you identify yourself, please, after you get settled?
My name is Joyce Pappas. I own 50% of the building that Myrna and Gloria rent from me. The very first shot that the inspector put up was from the first violation, because they sent it to me, and then it was confusing because that was from the very first violation. They had taken everything down off the doors, and then they said, no, it was inside. The violation was inside the building. And by the ordinance that they had, it didn't mention about the inside. And then later, I talked to Beth, and she said, oh, I sent you the wrong picture. Okay, because I went down there and I tried to solve this problem. And then they said, no, that was the wrong picture, that it was a violation inside the building, the doorway. So they really didn't get a clear picture of what actually happened on December 3rd to the 8th. Okay, they were talking about outside, and the violation was on the inside. This is what was told to me. Okay, so.
Thank you. Do you have any other witnesses? No. Does the board have any questions of these witnesses?
Any questions?
The city?
I have no questions. Thank you.
I'll ask you to summarize your case.
Briefly, thank you. The picture presented before the board, this is actually taken on the 22nd. So as you can see the blue tape, Gloria and I met. We actually,
This is November 26th?
this is November 22nd. So the original violation was on the 8th, came back out on the 22nd, took this photograph showing there was still a violation occurring. And the reason for my question to Gloria was, we had met, we measured this, put a yardstick up, and we actually put the tape up to show where these were. So this was almost over a year old, this tape, and it's still out there. So that was that. I also have another picture from later on, but it's taking so long to load the pictures up. But briefly, regardless of any discussion of the interior, as we say, there was still a violation on the exterior. As you're all aware, there's multiple aspects to that code. So you could have 3 out of 10, but until you have 10 out of 10, you're not in compliance. So things had been fixed, but things were still left out. So unfortunately, they were still in violation as it goes along. Now, the other thing I would present to the board, just briefly, it just brings up a little more argument for the, and of course, my picture is on top of it. The treatment that they're alleging discriminatory in some way, shape, or form. These right here, this is just our system. 765 dodecanese, let me make this, see if I can make it full screen or at least show you. AP6 is our internal code for Appendix 6 of the Smart Code, which is outdoor display. So you can see 2018 765 dodecanese was cited for it. You can see it a little lower on, 793 twice for it. And some of them, I get complaints about them and I don't have any complaints and they get closed out. So any of the violations that they are alleging that they took pictures of today, yesterday, or whatever, I highly encourage for them to contact our office and they'll be treated exactly the same way as anybody else. But as you can see, there are other businesses on the docks. Now, there's other circumstances to make the board aware. Some people have railings and patios, so now they can have displays outside their store. So just because there is a business on the sponge docks, there are different rules applicable to where it's located, their setback, whether they have railings, whether they're on the corner, et cetera, et cetera. So each one has to be taken into consideration. And 2 years ago, in 2017, I went and visited every business. This packet was given to every business. As a matter of fact, I still keep copies in my car because I still have to go down there and periodically remind people. So this isn't a selective enforcement thing. It's not anything new to this board, and it's not anything new to the city or the tenants or the owners. So that's all the city has at this point in time.
Would you like to summarize your case also, please?
Well, if the city's opened the door to bringing up other alleged violations, I'd like to have the opportunity to have my clients explain that there are lots of factual violations that have not been cited for a long period of time. But I don't know if it's going to make any difference for the board. I would ask that admittedly, there's been a lot of confusion on the part of my clients. Several of the code sections concerning the SMART code were not given to my clients. They did receive the other citation ordinances, but not, a couple of them were not in the backup, causing them considerable confusion. Once they found out what the alleged violations were, in fact, they fixed it the next day. So I'd ask for a minimum fine for this particular situation because of this confusion and the short period of time that was involved. Thank you.
The public portion of this case is now closed. I'm ready to,
May I ask?
I'm ready to entertain a motion, and then we can ask questions.
Have discussion.
Discussion first.
No, a motion and
And then
then
discussion.
discussion, not questions.
Does anyone like to make a motion?
I sure will. I move that based on the testimony, evidence, facts presented in law, that Joyce Pappas Phoenicia Family Trust was in violation of section, APPB, Chapter 6, Outdoor Display of the City Code from November the 8th until December the 3rd, and a fine of $10 a day for 24 days, fine of $240. In addition, I move that the city be awarded $69.50 for the costs it incurred for prosecuting the case.
Who seconded? Thank you, Ms. Norfleet. Now, would the board like to discuss this?
Well, I will suggest that I think the fine is a tad light. I've lived in this beautiful city for over 20 years. I remember when the Sponge Docks was the Wild West. When anything went, you could have anything on the sidewalk. You, as a tourist, you couldn't even get down the sidewalk. You still can't some places today. I think the ordinance is super, and I think it's great for the businesses there as well, although they don't agree with me right now. But I think my only concern, I'll go along with your fine suggestion, but I wanted to have my say here that I can't believe these store owners want to block egress or exit from their stores. And when they violate the code, that's what they're doing. If all of a sudden there's a fire in the back room, they can't get out either. Customers can't get out. It's difficult enough on the Sponge Docks on a crowded Saturday or Sunday to even walk down the street. I'm sort of surprised why the city doesn't close the street on certain days, and they do on certain big holidays. Anyway, I think I've had my say about these ordinances.
We have a motion on the floor. Bobby, would you like a roll call, please?
Mrs. Chilior?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
Thank you for your time.
Amazing. An order will be issued with 10 days and mailed to you.
You want me to go ahead and summarize?
Sure.
So, Mr. Elliott, I know how this works, but I've been asked to summarize the case. So the property owner has been found in violation of this code section that has been cited for 24 days at $10 a day, and the Code Enforcement Board has also awarded prosecution costs of $69.50. According to my math, it's $309.50 for this particular violation. The order will be issued within 10 days. It'll be mailed to the property owner at the address listed in the property appraiser's address. If you have any questions about what happened at the hearing today, you can contact Code Enforcement after the meeting today. Thank you.
Thank you. The next item on our agenda, you folks have listed as number 11, but it's now number 2. Is anyone present for this item? This would be for item number 19-80000807, 793 Dodecan East Boulevard. George Bilius?
I believe there's no one here.
Gloria, aren't you? Yes, I'm representing that. Yes, that is my store. And it's the same identical thing as we had at 713, which we had the same
thank
idea.
you.
We were doing the same thing, and it's, nothing changed. It's just a different
The-
store.
We'll get to your case one
Okay.
second. We
All
just
right.
have to go through the
Okay.
official procedures. Thank you.
Mm-hmm.
Do you have any legal objections as to why the city evidence should not be received?
No,
Thank you.
no.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is another repeat violator case for very similar violations as the one previous. The case before the board is 19-800000807. It's a repeat violator from case 18-800000393, both for violations of Appendix B, Chapter 6 of the Smart Code. Property owner at 793 Dodecan East Boulevard is listed as George Bilius, I believe. Exhibit number 1 going before the board are all the photographs. Exhibit number 2, all notices of hearing and notice of violations. Exhibit 3, administrative docs, case summary, previous board orders, and property appraiser and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign, and the affidavit of prosecution costs is exhibit number 5. All my photographs and exhibits are given to the violator, exact copies of what's being presented to the board. All my notices are mailed to the property owner record based on the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return receipt, as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Thank you.
As with the previous case, this started on November 8th, working the off-duty detail, observed the violations. We have had contact with the owner and the tenant, as stated before. Same basic violations, outdoor display violations under Appendix B, Chapter 6 of the Smart Code, racks outside the business over 36 inches high, merchandise hung from the door, and less than 24 inches of clearance on the sides of the doors. Now, there should be a correction to that. The code is actually 18 inches. I cited in both the cases 24 inches, but it has to be 18 inches. But in this case, it was right in the door, as you can see from the photographs. November 12th, repeat violator, notice of hearing was mailed. The green card was returned to our office signed. November 22nd, conducted a reinspection. Still not in compliance. There were still displays blocking the door and over 3 feet in height. December 2nd of 2019, I inspected it, and it's still not in compliance. I added photos as well. We did a deferral again, as with the previous case, at the request of the owner. And on December 3rd, I re-inspected it, and it was in compliance during daytime hours. Posted the property on December 22nd. This one, as before, had the same period of time, November 8th, 2019 to December 3rd, 2019 of being in violation. You can see clearly in the photographs, well over 3 feet, items hanging from the doors, and inside, within that 18 inches inside the doorway. Those are not only city code violations, they're also violations of Americans with Disability Act and the Fire Code. And as it was previously stated by a board member, one of the biggest issues with that is egress out of the building. In case of a fire, you get tangled up in the merchandise. So that's all the city has at this point in time.
Board members have any question for the city? Previous fine?
It was established with no fines.
No fine established?
Yes.
Thank you. Would you like to present your case now, please?
I'd offer to stipulate that the facts are the same as the prior case, and if we could stipulate that the board's decision is fair, and we'll go along with that as well in this case, and save some time for the board and people in the audience.
Thank you.
I have no objection.
Do you have questions? Do you have questions for the
I have no questions.
board? Have any questions?
Summary then.
Would you like to summarize?
No, I think we're good, thank you.
That was your summary, I assume?
Yes, ma'am.
Thank you. The public portion of this case is now closed. I'll hear a motion if the board would like to make one.
Based on the testimony and the evidence, facts presented by law, that the respondent, George Bilius, was in violation of outdoor display City Code APPB, Chapter 6 of the Tarpon Springs City Code from November the 8th to December the 3rd, a fine of $10 a day for 24 days, or $240 in addition. In addition, I move that $69.50 for the cost incurred in prosecuting the case.
Thank you. Do I hear a second?
Second.
Thank you. Call. Bobby. Call the roll, please.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
And
So I'll go ahead and summarize it. Mr. Elliott, this is the same as the last case. The City Code Enforcement Board has found a violation of City Code Appendix B, Chapter 6, outdoor display. Found a repeat violation from November the 8th through December the 3rd, and have fined $10 a day for those 24 days, and also awarded the city $69.50 for prosecution costs. It'll be reduced to order. It'll be issued in about 10 days, and it'll be mailed to the property owner at the property address listed by the property appraiser's office. If you have any questions, you can talk to code enforcement after the meeting.
Thank you.
thank y'all for coming.
Thank you.
Next item on the agenda, you have listed as number 4. We renumbered it number 3. Item number 19-8000743, 1310 East Tarpon Avenue, Joseph T. Risotto. If you'd come forward, please, we'd appreciate that. Unless you have objections, the board will, the city will present some evidence to the board. You've already seen that.
Please go ahead.
Thank you.
Your name, sir, is, are you Joseph Risotto?
Yes, I am.
Did I say it right? Risotto?
Risotto.
Risotto, thank you.
Close enough.
Relationship to.
Is this your property?
Yes, it is.
Thank you.
I just missed, did he have any objection to the paperwork? Okay,
He said
thank
no.
you. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board is 19-800000743. The property address is 1310 East Tarpon Avenue. Joseph Risotto is the property owner listed for the record. There's no prior cases for this owner. Exhibit number 1 are all my photographs, screenshots. Exhibit number 2, all notices to include notice of violation, notice of hearing. Exhibit number 3, administrative documents, case summary, property appraiser and tax collector records, affidavit of posting and copy of the signer. Exhibit number 4, all the evidence and exhibits that were presented to the violator, exact copies of what's being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector databases. All notice violations and notice of hearing are sent both return receipt as well as first-class mail. And please accept all the exhibits into the record as evidence. Madam Chairman. Yes. Thanks.
Yes, ma'am. I
Accept
will
those
accept
into the record, thank you.
Thank you. We have had contact with the owner, both via phone calls, and he's made an office visit with Beth. On October 15th of this year, we had contact with the utility department and verified they had not hooked up a city sewer. The original case we found was a 2012 case under a different property owner, Patricia Zaff, Z-A-P-H, or Z-A-P-F. There was a quitclaim deed done, was completed. We're not sure of the circumstances behind the quitclaim deed, possibly by her heirs. We then sent out a new notice of violation to the current property owner, Mr. Risotto, who's present, to get the connection to the city sewer, which is required in the Young subdivision under City Ordinance 20-22. On October 15th, the notice of violation was mailed. It was returned signed by the property owner. On December 17th of this year, we conducted a reinspection. Basically, the reinspection, we don't go out and dig up anybody's yard or anything like that. We just confirm with the utilities department there's been a connection made, because you have to make reparations through the city. To get a connection to the city sewer, you have to get a permit and things like that. None of that had been done. Had contact with the property owner. He stated he was financially unable to hook up to the sewer system. So at that point in time, we were going to bring it to the code board to kind of decide a deadline and to take those facts into consideration and to come up with a reasonable time frame to take care of the issue. So on December 17th, the notice of hearing was mailed. It was returned, signed by the property owner. December 27th, posted the property and signed the affidavit of posting. On January 8th, they conducted the final inspection, which basically, again, is a paper inspection. We look in the system. We determine there's no utility connections been made to the address, and there's no sewer billing. So it's obviously not connected because you're not getting a bill. As stated, this is a violation of City Code 20-22, which requires anybody within a reasonable distance of a city sewer to have a mandatory connection to that city sewer in lieu of using a septic system. So that's all the city has at this point.
I have a question. Is this a residence?
Yes, it is a private residence. And if you're not familiar with the Young subdivision, it's the area south of Tarpon Avenue, east of US 19, north of Anderson Park. It's that group of subdivisions over there behind CVS.
Okay, thank you.
That whole subdivision, around 2010, I think, the city put in sewer lines, and I want to say probably 90%, maybe 95% of that subdivision's finally been connected to city sewer. This was one that we're going through cleaning up our records, realized hadn't been connected, determined there was a lien and some things like that, and determined the property ownership had changed. So the new owner was cited under that, but since they did a quick claim, the lien probably was not discovered, or any of that prior issues were not discovered. So here we are.
Thank you. Anyone else have questions for the city? Do you want to summarize your case?
He needs to present his case first.
Sorry, I got out of order.
That's all right.
Your turn, you get to present your case.
Well, I don't have really any issue with anything Officer Gassam has said. He and Ms. Hughes have been very, very nice people. I think they're a credit to the city of Tarpon Springs. I imagine all the folks that are on the board here, because you're on the board for the city, live here. I've only lived here since about 2015, but I try to be a good citizen. Now, I have owned property in 2 other municipalities in Pinellas County. I own 5635 24th Avenue North in St. Petersburg. I owned that for about 30 years. I also own 12345 Wild Acres Road in Largo. It never dawned on me when I had those houses that one day somebody would show up and say, guess what? You don't have a sewer, so we're going to hit you with a bill, because all those places had it. Now, I have no other defense here other than, A, I am poor. I cannot afford pay. I went down and tried to do everything that you folks suggested. I came down here to City Hall. I met a lady named Lane, I guess. She's a very nice lady also. Told me that I could sign up, get on a payment plan to pay the $2,000 for that. I'm willing to do that. I called a plumber. The plumber wants like $7,000 to hook me up. I do not have $7,000. It was stupid to go over here and comply with her and get the deed if I can't afford the plumber. Now, I have been ill recently, and I want you to know I know I'm under oath. Okay, I brought my medical bills that I have had to pay since September. Out of pocket, I've had to pay $3,097 on top of what my insurance paid. I did not bring them, but I probably should have. At home, I have another $3,087 worth of bills waiting to be paid. I have to ask myself as I sit here in front of my neighbors, who would you pay? Would you pay a plumber, or would you pay the people that are keeping you breathing? I'm opting for the people to keep me breathing, and I'm not trying to be dramatic here. It's just the situation of my life. Now, the reason I chose to come here is because, first, I don't want you to think that I'm just blowing this off, that I don't care about Officer Gassam, or I don't care about you folks. I can only come here and try to defend myself. I also understand something that Mr. Trask may know as an attorney, and that's that he who defends himself in court has a fool for a client. Well, I may be a fool, but this is all I have. Okay, I find it amazing that the city would send me a paper that says if I don't get into compliance, you're going to charge me $250 a day fine. That means that in the course of the first 9 days of the month, if I didn't eat, I didn't drink, I didn't drive my car, I didn't pay for the homeowner's insurance, you'd have all my money. That doesn't seem fair to me. I also understand from talking to Ms. Hughes, again, who's a very nice lady, that the previous owner of the house, you have a lien against her for $118,000 because you've been billing her $50 a day, and the woman has been dead since 2013. That to me just seems a tad punitive. Now, the city of Tarpon Springs, according to Google, was incorporated in 1887. My house was built in 1952. And in 60 years since then, of over 125 years, it took you that long to decide to provide sewerage, which most other municipalities have for their own homeowners. Seems strange to me that you get punished for that. And I thought I needed to come here today and say that. Now, again, I take no issue at all with Officer Gassam, but I just think that this is wrong, that it is just unfair to be poor. And if I could do anything about this, I would. I don't know what else to say. That's what I came for.
Do you have questions for them?
I have no questions.
Does the board have questions? I do.
I just have one question for you, sir. Do you still own those other properties as well?
No, I do not.
Okay.
I inherited this property from Ms. Zaff, who owned it. She's the lady that has the lien against her for $118,000. I don't think she'll be paying. She's at the Union Cemetery of Pittsburgh. She was my significant other for about 20 years. When she died, she left me the house. It actually, originally, she died in 2013. It went to her son, and her son eventually willed it over to me, which was her last request. Okay?
When you took ownership of this property, did you conduct a title search to find out that there was a lien and that there were
No, I
violations?
did not. And what's amazing here is I'll be absolutely truthful. Okay, I guess it was about 2 years ago, a person in a white pickup truck from the city utility department, okay, came by my house, and I saw him, and I said, you know, I was just wondering, is this house hooked up to the sewer system? And he pointed to what looked like a piece of white PCV pipe out by my sidewalk and said, yeah, you're hooked up to it. So I always assumed that my house was on the sewer system. I have a septic tank that I never even put anything into because I didn't think I needed it, didn't think it was there. That off the cuff, and again, I'm not trying to point a finger at him. I'm just telling you what I think. I am not a plumber. I am not a municipal employee. I wouldn't know the difference. I don't know a hammer from a screwdriver, to be truthful.
I have one other question, sir.
Sure.
Did your other properties have septic systems?
No, they
Your
had
other
municipal.
Municipal sewer. So you received a bill on a regular basis at your other properties for sewerage?
Yes.
Sewer? I see.
Okay, and
But if
I got news for you. In the time I've had the house, madam, I can't see your name for here, but
Mrs. Tellier.
Ms. Tellier, but, you know, the ladies right down the hallway here in the collection department know me. I pay my water bill here in person. I mean, I'm always driving around the city, okay? I stop in and just pay. It saves me the 44 cents a month on the stamp. But
My only question to you, sir, was that if you thought you were hooked to the sewer, didn't you think it was odd that you didn't get a regular bill on a monthly basis?
I presume that the bill that you give me for the water and the garbage pickup is the same bill.
Sewer bill, I see.
All my other properties, okay, the one in Largo, the one in St. Petersburg, that was all incorporated into the utility bill.
I see. I see. It wasn't itemized.
No, it's just there it was. You pay it, nobody ever bothered you.
Anyone else with a question? Would you like to summarize your case, Officer Gasson?
Just briefly, I mean, the one interesting note, and I didn't get an opportunity to ask them the questions about it, but he said it was as a significant other, which if she was the significant other back in around April 2016, or so, 2012-ish, when this whole case started. The original case, which was February 13th of 2013, was when there was a code board hearing. Not to be aware of getting a notice from the city. And again, that would just be an interesting thought. The other issue I would also point out is, as you stated, the utility bill is fairly clear about your consumption and usage. You guys all get city utility bills, so you know what they look like. Other than that, you know, I know at least one person sitting at this board that had to get a mandatory connection to the city sewer because they happen to live in that same general area. So yes, it needs to be done, and it's for obvious reasons. Even as Mr. Risotto stated, that's probably a 52-year-old septic tank then. So that's kind of the reason why the city cares about it so much. We can all imagine that 52-year-old septic system was not up to current codes and things like that. So that's the reason why we're here. Unfortunately, he got caught up in some things that may have happened paperwork-wise, and got the property quitclaimed to him, and the liens were never discovered. Otherwise, we might have been able to handle this ahead of time. So, but that's all the city has at this point in time.
May I say something at this point?
Yes, sir, you get to summarize your case now.
Okay, well, in all fairness, Officer Gasmy probably doesn't know this, but when this happened and Ms. Zaff had the house, Ms. Zaff was very, very, very sick, you know? And as a matter of fact, she was kind of concerned about this at the end of her life. And I tried to explain to her, you know, sewage isn't your big problem right now because, you know, you're close to meeting your maker. I don't mean to sound funny there or anything. Okay, but she asked me to handle this. I wrote a letter, which I have a copy of right here, to former Mayor Archie, okay? And I explained this to him. And he, doing what mayors do, passed it off to City Manager Licouris, who I believe is still the city manager here. Is that correct?
Yes.
Okay. Mr. Licouris called me one day while I was at the hospital, okay? And he made it sound like this was, you know, no problem, so we can just make this, you know, the fine and everything will just go away. And I sent him another letter I wrote to him, which I brought a copy of, okay, thanking him for his concern and his phone call. Woe would I know that it would come to this so many years later. So it's not like I didn't pay attention, or Ms. Zaff didn't try to pay attention to this. She was just too sick at that time to do anything.
Thank you. The public portion of the case is now closed. I'm ready to,
It's too late to ask a question about the last statement there. I just wondered if there was any way we could get a hold of Licouris to find out.
Doesn't matter.
Doesn't matter? Okay.
I'm ready to entertain a motion.
I move that based on the testimony, evidence, and facts presented by law, that at the time of the alleged violation, sections City Code 20-22 of the Code of Ordinances for the City of Tarpon Springs was in force and effect, and the respondent was in violation thereof.
Do I hear a second?
I second.
Thank you. Is there any discussion from the board?
Yeah. Wow. What a dilemma. I'm not sure if he shopped around to get prices to have that work done, but I think 5,000, 6,000, 7,000 is way high.
I want you to know, sir, that I do have.
This, I'm sorry, sir.
I'm sorry, my apologies.
You and I can't discuss. There's doing two of them on my street right now, and I can stop and ask them how much they're paying, but they're doing the same thing because the houses never got done before. I feel real sorry for this gentleman who's kind of inherited this thing. He's gonna have to do the sewer. He's gonna have to do it. There's no doubt about it. That's the local law. But we could minimize the other with something silly like 120 days to get the work done, after that, $1 a day or something. I mean, I don't
After we
see where.
establish a violation, we can
I
discuss
don't
some of
know that
that.
it's his, I don't know, Officer Gasson may argue with me later, but,
No, at this point, we just need to establish it, and then
Yeah.
we can discuss that if I'm
yeah,
correct.
well, that's my
on this.
feeling anyway at this point, so.
Alrighty. I'm gonna call for.
I have a question
Okay.
that I'd like to ask us. Do the 115,000, whatever happened to that lien? Is it still in effect?
Yes,
The lien, if it was recorded, it would be in effect for 20 years.
So it's still in effect?
Yes.
Yes, so
If it was
100,
done-
it's 115 plus, plus, plus.
Yeah.
Yeah.
Excuse me, could I ask something?
No.
Okay, I'm sorry.
Call roll, please.
Mrs. Tellier? Yes. Ms. Norfleet?
Yes.
Mr. Robinson? Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Yes. Do you have any additional input?
I'm going to let this one ride in your hands.
Thank you.
That's the whole reason to bring it here in the
Do you
first
have
place.
any input for when you might anticipate compliance to the code?
Ma'am, I was meant to say that, I didn't know I couldn't speak, but the fact of the matter is I have another plumber coming out tomorrow to give me an estimate. They're supposed to be there between 1 and 4:30. It's not that I don't want to do this, I just can't afford to do this.
We
And I don't
understand.
find it, I find it extraordinarily uncomfortable to have to come here and say all this about myself.
We understand. Do you think that it would take 3 months to have the sewer connected? 2
Well,
months?
again, it depends on how much it costs. It's not a question of, it's a question of what the dollars are. It's not, I don't know the answer to that. If you know somebody, Mr. Kramer, that is less, by God, I will give him a call as soon as I leave here.
We need to have an estimate of about what time period you think you need to get it connected.
3 or 4 months.
Okay. Board, I'm ready to entertain a motion on the second part of the case.
I move that the respondent shall have until April the 13th to bring the property into compliance of Code Section 20-22, or suffer a fine of $100 a day for each day thereafter the respondent remains in violation of said code.
Do I hear a second?
We need a second before you get discussion.
Okay. What if,
Do I
it
hear-
dies if it's something?
I don't hear a second. That motion has died for lack of a second. Do I have another motion?
I move that the respondent shall have until, what was the date you said?
April 13th,
April 13th, to bring the property into compliance with Code Section
20-22.
20-22. Or suffer $1 per day for each day thereafter respondent remain in violation of said code section.
I second. Our second was, I'm sorry? I second.
Okay.
Call for vote, please.
Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
No.
Mrs. Archer?
Yes.
Ms. Wade?
No.
Motion carries.
Good luck to you.
Good luck to you. You have, an order will be issued in 10 days and mailed to you.
The order itself will provide that you've been found in violation of Code Section 20-22 and give you until April 13th to come into compliance. Should you fail to bring the property into compliance by that date, the fine will begin to run.
Okay. That's it. Thank you very much for your time. I appreciate it.
For coming, we know it's hard. Now we're going to go to what's listed on your paper as item number 2. This is case number 19-80000719. It's a parcel 112715 87786 019 0160. It's a vacant lot next to 621 Eunice. The owners are Teresa Young and Rue Tallarino.
I'm Michael Steffen. I'm the attorney for Teresa Young and Rue Talentino, and I have no objection to the evidence submitted.
Thank you. Would you repeat your name, please?
Michael Steffen, Steffen.
Officer Steve Gasson, City of Tarpon Springs Police Department. Case before the board 19-800000719. As stated, it's a vacant lot next to 621 Eunice, parcel number 1127150877860190160. Exhibit number 1 going before the board are all my photographs. All notices, including a notice of violation and notice of hearings, are Exhibit 2. Exhibit 3, administrative documents, case summary, property appraiser, and tax collector records. And Exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs that were given to the board, or the violator, are exact copies of what's being presented to the board. All my notices were mailed based on the property appraiser and tax collector's determination of address. All notice of violations and notice of hearing are sent return receipt as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Yes, thank you. Bobby?
Thank you. We have had contact with the owner's attorney, the owner's spouse. A lot of people have contacted us about this property. It's a vacant lot out on the west side of town that the intention is to develop the property. I got a complaint about it being overgrown on October 4th of last year. The lot was overgrown, the grass overgrown, the sidewalk, and I noted at that time that there were 2 large piles of dirt that were dumped on the property. So I checked in the system and there was no active building permits. The property had recently changed hands, so I had worked cases on the property under the previous owner before and knew there was no dirt on the property, so now we had a couple piles of dirt, so it raised my suspicions. On October 4th, the notice of violation was mailed. It was returned signed by the property owner. October 23rd, conducted a reinspection, still not in compliance. The grass was still tall around the edges and the fence lines. Again, there was no permit for the fill dirt, so the piles of dirt can't be stored on the residential property. Once there's a permit for fill or whatever, it can be stored there. And then there was also now mulch added to the pile in the southeast corner. On November 15th, we mailed a notice of hearing. It was signed by the property owner. December 27th, I posted the property and signed the affidavit. January 8th, I re-inspected, and there's still no permit pulled, and there's more dirt dumped on the property. I cited under City Code 8-40 and 8-52, which is the nuisance prohibitions, dealing with mowing the grass and taking care of the property, not having rubbish, debris, and things like that. I left out all the city codes that had to do with fill, site plans, building permits. We did find out partially through the process that their intent is to build a house on the property. They're working through that, and I think council's probably going to explain that a little bit more in detail, and that's why he's here. They are actively working on it, but they had some issues kind of with the parcel, its sizing, what it used to be, and so they're trying to get through all that with planning and zoning, and as you can appreciate, sometimes the city's not the most expeditious about working through things like that. So we, in some cases, aren't necessarily sure if that's just somebody's telling us they're taking care of all this and they just really want to store tons of dirt on their property. I mean, it's happened before. So we brought it to Code Board, and Council and I have discussed this, and the long and short of it is they just need some time, and that's what the city's position is as well. We obviously want to get it developed and taken care of, and that's kind of why we didn't go down the road of citing for the specifics about site planning for fill dirt and things like that, and we left it very generic as we called the piles of dirt debris. So that's where we're at.
Board have any questions for an officer?
What do you mean by filter?
A house, a residence. That they're intending on, it's residentially zoned. They're not trying, as far as I know, they're not trying to change zoning or anything. They are trying to build a residential home and live in Tarpon Springs.
On those pictures, you're talking about the grass on the other side of the fence that's up?
Most of the
to
grass
fence?
has been mowed. What more the issue is now is the piles of dirt and the building materials that are starting to kind of get stored out there in the absence of any building permits. If you read the definition of debris, it's very broad, and it talks about landscaping materials, unused materials, and that's why I kind of left it that way. By going down codes regarding site plans and things like that, our time frames change significantly. So this leaves it a little bit more open, and as it turns out, they are actively working on that, and we've had the attorney's assurance that that is the case, that they have every intent to get a building permit, and that's what the city's position is. As soon as they get the building permit, then they would be in compliance of those things, because it's now no longer unused material, it's now used material.
Thank you. Would you like to present your case, please?
Am I allowed
Or you
a
want to
question?
ask questions first?
Just one question, Officer Gasson.
Sure.
I know this is a while and you probably don't read every email, but Can you confirm that you never actually spoke with Ms. Young? Or
did-
Ms. Tellerino?
I did not, my clerk had.
Okay.
No, I take that back, my clerk had not.
Okay, so the only person that you would have spoken with, and again, it's in this lengthy packet, would be myself, which is recently in the last 10 days, let's say.
That would be a fair statement.
And then prior to that, you spoke with Nate Tellerino, correct?
And that's what I would have, at that time, considered the owner, or the representative of the property. So,
Understood.
yes.
And you understand that Nate is not an owner affirmatively on the property according to record?
We do now, yes.
Okay. No further questions, Chairman.
Would you like to present your case,
Yes, ma'am.
please?
So what we have here is a simple miscommunication lapse. So this isn't something that they have been sitting on forever. The parcel was purchased late August from the neighbor that owned it. They have every intention to build a house for Miss Young. Miss Young currently lives with the Tellerinos. They are probably 15 houses over on Castle Terrace. It connects right to Eunice. I understand there is fill dirt there. I'm not going to dispute that. Where it came from was the neighbor, and I have the address. They have an open permit for a pool, and that's the basis of the fill dirt. So it's not like they're trying to spread their own fill dirt without a permit. That's not what's going on. It's literally just from a hole from the pool. And that address is, hang on here, 1 second. On Margarita, which is probably, I would say, 300-400 feet away. And that permit was number 192373. It's still an active permit for a pool. So that's where that dirt came from. It wasn't anything that was malicious as far as I'm going to build my own house and not tell the city. I have seen plans for this home. In fact, they were sitting on her desk today. They're actively trying to get to the city to get it done. There is some emails, and there are in the record on Exhibit 3 going back and forth where Mr. Tellerino was basically CCing Ms. Beth over there about getting a variance perhaps and going back and forth. But the architect and all that stuff has been squared away. So my clients are just asking for a little bit of time. They had no malicious intent, and they apologize for getting this far, but that's why they hired me, Ms. Young, and Ms. Tellerino, not Mr., to come before the board and kind of explain their position.
Does the board have any questions? I did one. Was the pool dirt inadvertently stored there, temporarily stored there, or given to them so they could use it to level their lot?
No. So from my understanding is that it was authorized as just a neighborly good thing to do. They didn't have a place based on their positioning their driveway. They didn't want to stick a bunch of dirt there. So my clients had no intention of actually spreading that dirt. I have the understanding that they were going to return it back to him. He may be doing pavers. I haven't reviewed his entire permit, but that's the understanding.
I have a question. What's the status of the permit?
So they were going back and forth. My understanding, and the client told me that their goal is to get the permit done next week and filed with the city. And that
Permit hadn't even been
correct.
filed.
They were going back and forth because there was an issue with, I believe, the sizing of the home based on the setbacks. They had some meetings with the city and are firmly trying to do it, but they only purchased this about less than 100 days ago. And they do have site plans, and they're ready to go within the next, I would say, 30 days. The permit will be sitting in the city.
They're asking for a variance as well?
That I'm unsure. I'm not briefed on that matter, sir. But she does want to build. She does live there. Miss Young lives with the Tellerinos, and she wants to be close to her grandkids. So she's going to build there. It's not something she bought as an investment. There's a 0% chance of that.
Would you like to summarize?
Just briefly, I mean, as I stated, the information given by council regarding the dirt, they get their building permit issued by the city, and unless they're using it for fill, which would be allowed in their building permit, it's going to have to go anyway in order to prep the site. So either way, the building permit is kind of the crux, and in the city's position is once that building permit's issued within a period of time, and whatever we decide here, that would resolve the case, because the dirt's going to go one way or another. It'll be legal to spread it, or it's going to have to be removed by nature of the beast.
Thank you. Would you like to summarize?
Once again, this isn't a case of someone just buying a lot and putting a bunch of stuff on it. They thought they were doing the neighborly thing to do, per se. I can tell you that Miss Young is quite concerned about the matter, and that's why I was brought in. Mr. Tellerino's off the project, per se, and Miss Tellerino is going to be filing those permits swiftly, and they would just ask the board for even 45 days to go ahead and get that permit in. And I really don't believe that it would take that much time. Even less would be acceptable.
Thank you. I'm closing the public portion of the case. Like to see if anybody would like to entertain a motion?
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 8-40 and 8-52 of the Code of the Ordinance of the City of Tarpon Springs was enforced in effect. The respondent was in violation thereof.
Second.
Any question, discussion from the board? Would you like to call the roll, please, Bobby?
Mrs. Telliar? Yes. Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
Order will be issued within 10
We need
days.
to do the second half of the order, the compliance date and the fine.
Oh, sorry. Part 2. Would like to make a motion, anyone, please?
I'll move that the respondent shall have until February the 13th to bring the property into compliance with sections, city codes 840 and 852. And after that, a fine of $100 a day will be in effect for the violation of those codes.
Do I hear a second?
I second.
Can we ask questions?
Yes?
Can they get a permit in that town? Permits are not easy to get. Can they get a permit by that time?
So you're supposed to be discussing amongst yourself as to what you're gonna do?
He asked for 45 days, so
Yeah.
I assume he felt comfortable with that.
Madam Chair, you can open up the floor again if you want. So if you ask the city that question, you're going to have to give the opportunity to the respondent to also respond to that, so.
All right, I'll reopen it.
If I was given the opportunity, I was going to ask the city we would be satisfied with 60 days, and that would pretty much cover all the bases. So he stated 45, this gives him a little bit of latitude with that, because there always is some potential issues, so.
Then can I amend the motion to March the, what, that would be March the 10th? 60
Before
days.
you do that, let's make sure he gets a chance.
So just a point of clarification, as opposed to a permit, if the city determines for whatever reason that they're backed up and can't get this done for 90 days, can we make that an application, meaning that the client has affirmatively taken the steps and made an application? Because we have no control over the length of the city. Someone could be terminated, et cetera, et cetera.
So he needs to bring the property into compliance, whatever way it takes to bring it into compliance, such as remove the dirt, cut the grass. Okay, it has nothing to do with the permit. He is suggesting that if there's a building permit in place, maybe that we could, address that at the same time. But that's not the issue. The issue is the violations 8-40 and 8-52. So they can remove the dirt tomorrow, they can cut the grass tomorrow. You're giving them, so far, if the motion is March the 10th, 2 months to do that.
Yeah.
So that's really the issue. Don't get caught up in the permit and when it's issued or not. But you have never,
Giving somebody 2 months to mow grass and move dirt.
what I was going to say is taking a position that when someone files an application, that they're in compliance with the code. Even in a permitting situation, that would not fly, because they could file an application that is completely inappropriate. They come into compliance and then nothing ever happens with it. So it's the actual issuance of a permit, if that was the building permit violation, but that's not what you've got here. So I would focus you on 8-40 and 8-52, the code violations that are being cited, which is the dirt and the grass. So,
Okay, can I say something
if that was
else?
of any help. So is the motion March 10th, 2020, and $100?
Can I,
Second.
Yeah, I would second that.
Now you can discuss it.
okay. I think the $100 is a little much. Isn't this their first time before us? And I would like to at least go to 50, if it's all right. If not,
Whose motion was it? Yours? Do you want to?
Sticking with 100 if you're asking me.
okay.
He's preferring to leave his motion at $100 per day. Not complied with by March
March
10th.
the 10th, we said, correct.
Do I hear a second?
Yeah, second.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Wade?
Yes. now.
Okay, Mr. Stephanie, your client, the property owners have been found in violation of 8-40 and 8-52 of the city code, been given until March the 10th to come into compliance. Should your clients fail to bring the property into compliance by that date, a $100 a day fine will be issued. The order will be issued within 10 days and provided to the property owner at the address listed by the property appraiser's address. If you have any questions after the meeting, please feel free to contact code enforcement or myself, and I'd be happy to answer your questions.
Thank you for your time.
Thank you. Board, look for, in your packet, item number 12, which is now case number 5 for us. This is item number 19-80000, 875 100 North Ring Avenue, Ingrid Jones. Are you Miss Jones?
I'm her daughter. I take care of her and I take care of the house.
And is there a legal document that gives? What's your name, please?
Rita Herman.
Rita Herman? And do you have any documentation that you can represent this property?
She was allowed previously on the previous case, if that makes any difference to the board or the chair. She is the daughter of the property owner.
That's fine.
All right, thank you.
Thank you.
Do you have any legal objection to why the city evidence should not be received into evidence?
No.
Thank you.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is a repeat violator case. The original case that created as a repeat violator is 18-800000585. It was a violation of a number of city codes, 8-40, 852, 6-1, IPMC 30413, 30413 sub 1, 30413 sub 2. At that time, there were no fines. They complied before the $25 a day fine was assessed. Unfortunately, the prosecution costs in that case have not been paid yet. The case before the board is 19-800000875. The property address is 100 North Ring Avenue, and the listed property owner is Ingrid Jones. Exhibit number 1 going before the board are all my photographs. Exhibit 2, all my notices, including my notice of violation and notice of hearing. Exhibit number 3, administrative documents, including the case summary, previous board orders, property appraiser and tax collector records. Exhibit number 4, affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All my photographs and exhibits that were given to the alleged violator are exact copies of what's being presented at the board, or in this case, her daughter. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent return receipt as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Thank you, Bobby.
Yes, ma'am.
We have had contact with the owner in our office from, actually, the owner's daughter who's present. The case started on December 11, 2019. I was conducting inspections in the area on adjacent properties and noticed numerous violations on this one. Trash cans were in public view. The property is overgrown. There was trash and debris on the property. There was mattress, old rug, old cushions, etc. On December 12th of 2019, the repeat violator notice of hearing was mailed. No green cards were returned. December 27th, sign was posted and affidavit of posting was signed. I also conducted a reinspection on December 27th, and I noted it was in compliance. We had received a phone call from the office owner around December 20th, so we used the compliance date of December 20th, 2019, when they stated it was ready for inspection. The property was in violation from the date of the initial inspection of December 11th, 2019, until it was complied on December 20th. For my math shows that to be in 9 days. It was a violation of city codes 8-40, 8-52, 8-22, and 8-16. And I think what's before the board, I don't have my paperwork, I'm sure it's 8-40 and 8-52.
Yes.
Thank you.
Does the board have any questions for city staff? Do you have a question for the officer? This part's just where you ask a question.
No.
Okay, thank you. Do Would you like to present your side of the case?
I don't have a side. I mean, I'm busy with my mom. I take complete care of her. I just let it slide.
Thank you. Does the board have any questions for the owner? I just want, do you and your mother live at that residence?
Mhm.
Okay, thank you. Do you have questions for her?
I do not.
Can you summarize your case?
I think I have, thank you.
Anything else you'd like to say? The public portion of the case is now closed. I'm ready to entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof. Was that supposed to be a repeat?
This is a repeat violator case, so we need to that one motion that addresses the time frame and the dollar amount of the fine.
The different page.
Okay, that from 1211 to 1220, and then do you have a recommended?
Is there a previous, what's their previous fine?
Previously, they were assessed $25, but they came into compliance prior to being fined.
$50 per day. In addition, the prosecution costs of $87 to be added.
I second.
Okay.
I hear second.
I second, yeah. Oops.
Bobby, would you like to do a roll call, please?
Mrs. Telliard?
Yes.
Okay. Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Mrs. Wade?
Yes.
Motion carries.
Summarize?
Yes, please.
So, Mrs. Herman, your mother has been found in violation of Code Sections 8-40 and 8-52 for the time period of December 11th to December 20th, 9 days, and have been fined $50 a day for each day that it was in non-compliance. The Code Enforcement Board also awarded the city $87 in prosecution costs. An order will be entered within the next 10 days. It'll be sent to your mother at the address listed in the property appraiser's address listings. If you have any questions after the meeting, you can contact Code Enforcement, and they'll be able to answer your questions. Okay? Thank you.
Thank you for coming.
Thank you.
Board, on your packet, it's listed as item number 5. It's item number 6 for us here today. This is 19-8000768. Address is 714 North Avenue. Nicole Lee, Gracie Ellsworth, and Noel Jones.
No, you were in
No.
you read 7.
I'm read the wrong one, I'm sorry.
One above that. That's
Go
all.
back up one square on your book. 19-8000766, and this was to be established. It's a vacant lot at 721 North Avenue, and the owner is Elizabeth D. King. Are you Ms. King?
Yes, I am.
Thank you for coming. Do you have any objection to the city presenting their evidence?
No, I don't.
Thank you.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case 19-800000766. This is a vacant lot north of the address 721 North Avenue. It's parcel number 182716910800030080. Property owner is listed as Elizabeth King. Exhibit number 1, going before the board, are all my photographs. Exhibit 2, my notices, including notice of hearing and notice of violations. Exhibit number 3 is administrative documents, including the case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my photographs and exhibits that were given to the violator, exact copies of what's being presented to the board. All my notices are mailed to the property owner record based on the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violations and notice of hearings are sent both return receipt as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Thank you, Bobby.
Thank you. We have had contact with the owner via phone calls. Case started on October 25th of 2019. I was conducting area checks, inspections on other property in the area. And I noted that it seems like there were two properties. I believe Ms. King owns two of them right there on North Avenue. This particular one had a red Camaro parked on it, and I've seen it there numerous times, and we also had some in the past had it there and other cars being there. So it somewhat seemed like the lot's being used kind of as a parking lot. This is a residentially zoned district, and at the time there were no, the vehicle had no tags on it when I first inspected it. Later on it had a license plate attached to it, which was the red car. On November 29th, we sent a notice of violation. There was no mail returned. I conducted a reinspection on November 22nd of 2019. The red Camaro was still on the property. I checked it again, and it had tags on the vehicle, which was Juliet Victor Henry Alpha 24, and they were expired February 2019. And November 25th, the notice of hearing was mailed. It was returned signed. On December 27th of 2016, I posted the property and completed an affidavit of posting. On January 8th, I conducted a final inspection. The car's been moved, and it was currently in compliance, but I brought it before the board to be established because, as I stated before, it's occurred in the past. What the city's asking to be established for that property are violations of City Code 40.00, which you well understand is leaving abandoned vehicles, which includes unregistered, unlicensed, or vehicles that are inoperable. And then also a violation of City Code 25.03, which is the zoning, which deals with R60 and R70 residential areas. Basically, a parking lot is not an accepted use or a conditional use for residential property, so it can't be used as such. It is a vacant lot, but it cannot be used as a parking lot. You can build a house on it, make a daycare, things like that. So that's all the city has at this point for the consideration of the board for those two violations of those two city codes.
Thank you. Do you have any questions for the officer? Thank you. Would you like to present your case, please?
It's not my car, it's my nephew's. I had made every effort for him to move it. I actually called and asked what could I do to actually have it towed, because it's been towed over between him and my sister going round and round, and he's not telling any, it is true. There's one of I don't know why they think my property is a parking lot, so I do apologize. I don't have anything to say. He's telling the truth. It's just family. What's to say?
Thank you. Do you have any questions for her?
I don't have any questions.
Board have any questions for either of them?
You're talking about the dates from 10/25 to 1/8, correct?
I'm sorry?
10/25 to 1/8, that's when you, no?
She's in compliance. This is a new case.
Okay.
Yeah, it's not a repeat filer or anything
Okay.
like that.
Okay.
She's just being established.
Okay.
I'm sorry. Is it if I can talk? So also too, I asked for an extension because I kept getting on them, and they did give me an extension
I'm sorry,
for
an
it.
extension for what?
To have more time for them to move the car.
I thought we were currently in
The
compliance.
car was removed.
You're in compliance.
But when,
Is the car back there again?
Yeah. No. I think we're confused. She had asked for an extension, and we gave her an extension, but she is in compliance, so there's no monies involved or anything like that.
I'm just nervous and afraid. I've never been in court, never been in trouble. So
Fine, you're fine.
I'm sorry.
We're setting this as a property, establishing it as a property. There's no fine at this time. If this occurs again, then it's done, you're in trouble. So,
Question, can I actually call someone to remove? Because they do it all the
I
time.
have no idea.
We can
Not-
help you with that
Not
afterwards.
really our thing,
Yeah, it's okay.
sorry.
Yeah, we'll help you with that
All right.
afterwards.
Thank you.
Thank you. If nobody else has any questions, let's,
I move based on the testimony, evidence, facts presented in law at the time of the alleged violation, sections 40.00 and 25.03 of the Code of Ordinance of the City of Tarpon Springs were in full force and effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Bobby? There's no discussion, I want to make sure, sorry. Bobby?
Mrs. Chiliar? Yes. Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes. Would you like to summarize for us, please?
Ms. King, you've been found in violation of Code Section 40.00 and 25.03. There is no fine, there are no prosecution costs that have been established. If the property will be deemed a repeat violator if the same violations occur within the next 5-year period of time. And if that occurs, then the fines have the opportunity of being doubled up to $500 a day. So please try to keep the property into compliance, and then you won't have to worry about that. There will be an order issued. It'll be issued to you at the address listed by the property appraiser's address. It'll be issued in the next 10 days. If you have any questions, you can contact Mr. Gasson after the meeting. Okay, thank you.
Thank you.
Thanks for coming. Good luck.
Miss, they're going to help you out with a couple of things also.
Now we'll get back to the one that I messed up. We're on first page, item number 3 on your agenda, 19-8000720, 410 Village Drive, James and Elizabeth Simons. If anyone's here for that property, would you please come down? Thank you. Could you tell us who you are, please?
James Simons.
James Simons, thank
Yes,
you.
ma'am.
Do you have any objection to the city presenting their evidence?
Yes.
You have a legal objection.
I just think it's too disgusting for most people to see, but go ahead.
I understand.
You got to give it to them, or do they?
With your objections withdrawn?
Yeah.
Thank you.
Thank you. Officer Steve Gasson, City of Tarpon Springs Police Department, case number 19-8000720. The address is 410 Village Drive, James and Elizabeth Simons? Simons, for the listed property owner. Exhibit number 1 going before the board are all my photographs. All the notices to include notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are the administrative documents, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. All notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return receipt, as well as first-class mail. Madam Chairman, please accept these into the record as evidence once they make their trip.
Yes, ma'am.
We have had contact with the owner. He's made office visits. I personally haven't had contact, but Beth's talked to him. This case started in July in 2019. It was the result of a police call. The narratives attached to the case. In summary, Officer Rondos had gone to the address on July 30th, 2019, referenced Tarpon Springs Police Department case TS 19-18512. The house appears to be a hoarder house with limited egress, inability to get out of the house. House is very unsanitary. As trash is piled up all over the house. Feces and urine are present in the house. Sink in the kitchen is unusable, as you can see in the photographs. Trash has not been cleaned up or removed. The refrigerator had rotten food in it. At the time, the property owner's handicapped daughter also lived in the residence and is bedridden. On October 7th, I inspected the property and was able to inspect the outside. These photographs that were included were provided by Officer Rondos to me. I inspected the property, and there's numerous outside violations as well. The yard's overgrown, front and rear. The trees were blocking the sidewalk and the stop sign. The grass was overgrowing the sidewalk, and the trash cans were in view. On October 8th, 2019, notice of violation was mailed. It was returned unclaimed. On December 2nd, I conducted a re-inspection. We had extended it 30 days at the request by an office visit. It was still not in compliance at that time. On December 3rd, the notice of violation was mailed. No mail was returned to our office. December 27th, I posted the property and signed the affidavit of posting. I conducted a final inspection on January 8th and complied. Majority of the exterior violations, the outside of the house had been taken care of. The trash cans were in their proper place. But unfortunately, the duty to maintain private property, as you can see from the photographs, which is 8-40, and then City Code 6-1, which adopts the 2018 version of the International Property Maintenance Code, also known as IPMC. Under that, he was cited for general interior violations under IPMC 305.1. Primary issue with 305.1 states that the interior of a house needs to be kept in a sanitary condition. The next one
is IPMC 502.1, which is the required facilities in a dwelling, which deals with your ingress, your egress, getting out of the house, blocking exits, having alleyways or access points and things like that. And I'm sorry, that one's actually covered under 702.1. And then IPMC 309.1, there was a significant pest infestation in the house. There were roaches all over and ants and such. So that's the other IPMC violation. So that's what's before the board. The only two not up for consideration, and I don't know if your paperwork reflects it, 8-52 and 8-16 are in compliance at this point. So it's just the other violations that are before the board.
I'm sorry, I heard you say 309.1 of the IPMC.
305.1,
305, okay, thank you.
502.1, and 702.1.
Thank you.
And 309.1.
That's
So there's
what we
4
don't-
IPMCs.
We don't have the 309 listed?
No, on here.
Well, then disregard the 309.1, because apparently you don't have it.
Okay.
So,
But 8-40 and 8-52.
but that could be considered under the sanitary side of things, because you're not supposed to have bugs in your house.
I just wanted to make sure they had been properly notified of the ones we were addressing.
Yes.
Thank you.
40 and 52 have been,
Only 52 can
Oh,
you scratch
okay.
off, yes. Do you have questions for the officer?
No.
Okay, does the board have any questions? Would you like to present your side, sir?
Yes.
Go ahead.
In July, the reason why,
I'm going to ask you to speak into
Oh,
the
I'm
microphone
sorry,
because
I'm
we don't
sorry.
hear so well
Okay.
anymore.
in July, the police were called to our house by me because my wife, who is 81 years old and suffering from, she's just not mentally there anymore. She stole our van, and she doesn't have a driver's license. I've been hiding my keys for months, and she finally dug them out of my pants pocket, and she left. So I didn't know where she'd gone, so I called the police. And they came in the house, and they saw the disgusting mess that you've seen. My wife and I have been married for 39 years. She has been a semi-hoarder most of the time. We built our house in 1999, and that's when it really started getting bad. And we would argue, and that was our big argument about the stuff. She had a walk-in closet that right now she hasn't taken anything out of in the last 6 years. But I couldn't throw anything away because she's a hoarder. We have a daughter who is 44 years old, Heather. She is quadriplegic, developmentally disabled, nonverbal. She knows about 10 words or so. In July, she had developed a bed sore on her butt, pressure wound. And when I first saw it, I rolled her over, and I saw it, and I just about freaked. It was it looked like you could put 3 silver dollars in a stack. And I changed her 3 or 4 times every day, and where did it come from? Took her to the emergency room.
I'm going to redirect you to the issues of the property, okay? We
Oh.
understand your living is difficult.
Well, here's why I haven't fixed it. I took her down to a place in Clearwater, a rehabilitation place. She was down there for 36 days. I was down there with her every day. My wife, she went down maybe twice. So meanwhile, she was sitting at home and making a mess, even worse than it was before. I brought her home. She was home for 3 weeks, and she developed another sore.
Okay,
Well,
we need to keep you to the property parts, though, okay?
well, the property is a mess. You've seen the pictures. I mean, I haven't been able to do a thing. She's over in the Bayou Rehabilitation Center. She's been over there for 111 days. I go over there every morning from 7:15 till 8:15 at night. And when I get home, I don't feel like cleaning a dang thing. So that's why we are here. My brother will be coming down in about 3 weeks. I'm going to bring her home. I've got the pressure mattress for her bed, and 3 or 4 days before she goes home, I'm gonna order the new hospital bed, so she'll be able to, and I'm gonna have a nurse come in to give her the wound changes. That will be 3 or 4 weeks. We don't know. It's still not healed up, but at least it's going to be a lot closer.
The injuries are not pertinent to us. It's just the conditions of the home that make the difference here.
Well, I thought I might have to tell you why I haven't cleaned it up. That's it.
Does the city have questions for him?
No, I do not.
Staff? Board, excuse me?
Still living in it, right?
Pardon?
You're still living there?
Sleeping there at night.
Sir, you basically said that you've been trying to help your wife clean all of this up. But realistically, you haven't been able to make any headway.
Well, I forgot about that. My wife left me about 4 months ago. Went back to Illinois.
So the property is only yours and your daughter lives there at this time?
Yes. Well, my daughter doesn't. She lives
When she
over
comes back?
Yeah.
His daughter that's in the body.
Anybody else have a question? Public portion of the case is now closed. I'm ready to entertain a motion. Did I give you a chance to summarize, or did you need to?
I'm sorry?
I don't think I gave you a chance to summarize if you needed to.
I don't need to, thank you, though.
Okay, thank you.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, sections 8-40, 6-1, IPMC 305.1, IPMC 502.1, IPMC 702.1 of the Code of the Ordinance of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Do I hear a second?
Second.
Bobby? If there's no discussion?
Mrs. Chelior,
Yes.
Mr., excuse me, Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Your motion carries.
And we have a second part to this?
Are you asking me? I think some of it depends on now that his wife left. I think he has the opportunity to clean the stuff up. He has a little bit of time because I believe it sounds like his daughter is still in rehab. There are some agencies that can also help him with some of that stuff, but I think it's reasonable 45 days. And then it is pretty significant, especially, there's two aspects. One, I need to be contacted so I can re-inspect the interior of the property in order to put it in compliance. So I want to make sure you understand that. But it is pretty significant, especially bringing his daughter back in to that environment it should be basically unacceptable. And I would say $100 a day after that 45 days because of the serious aspect of it, as you all saw in the photographs. I mean, there's human feces on the rug.
No.
Or there is feces on the rug.
No, that is not true. Not true.
Well, that's what the officers informed me of, sir, so
there were
that's
a
all I-
couple officers that just did not know what they were doing. One woman checked on my daughter, looked at her chest, and she called the fire department to have a look. And I said, well, what'd you do that for? She says, she's got feces all over her chest. I says, no, ma'am, those are skin tags. I would never do that to my daughter. There were not human feces on any floor. The cats had barfed. They're by a cat litter box, and that was it. There was no human feces on the floor.
Thank you for clarifying that. Could I hear a motion?
I move that the respondent shall have until March 2nd to bring the property into compliance with code sections, that's all of them again, right?
Yes.
8-40, 6-1, IPMC 305-1, IPMC C 502.1, IPMC 702.1, or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said code sections.
I second.
Bobby?
Mrs. Hilliard?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
We are not here to try to get money from you. We want to give you a push to make sure your house is fit for your daughter's return. So that's why we're putting a fine on here, to give you a reminder. We are sympathetic to your situation, but we want you all safe. That's our bottom line. The attorney can summarize for us.
So, Mr. Simons, you and your wife have been found in violation of the code sections that were cited, given until March 2nd, 2020, to bring the property into compliance. Should you fail to bring the property into compliance by that time frame, a $100 a day fine will be assessed. An order will be issued. It'll be sent to you at the address listed by the property appraiser's records. That will be done within the next 10 days. Should you have any questions about what you need to do to bring the property into compliance, please contact Officer Gasson after the meeting. He'd be happy to talk to you about that. Do you have any questions, sir?
Yeah. You're expecting me to clean it up in just 45 days after my wife spent 21 years of getting it messed up.
Yes, sir, we
There
do.
is no way in hell that I can get it done, the whole house, in 45 days. Now, I can get Heather's bedroom, and I can get the kitchen and part of the living room, but there's no way of finishing up the living room, getting the dining room and the master bedroom done in 45 days. So just, I'll start writing checks now, I guess. That's just impossible. Unless
Sir,
one of you folks or all of you would like to come over and help, which I know you wouldn't, but
Okay, the board
that's just too soon. It truly is.
Okay, so you can stay in contact with the Code Enforcement Department, and if you need a little bit more time, you can ask them. They may
Okay.
come back here.
Okay.
But you need to make a good faith attempt to get
All
it
right,
into
okay.
compliance. Otherwise, the fine is going to run no matter what.
No problem, no
Okay,
problem.
all right, thank you.
Okay. I do have one question. Whose idea was this to put in my front yard? And the second question is, who's it for?
Okay, sir, you can talk to the Code Enforcement Department after the meeting, and they can tell you about that.
Aren't you in charge of rules?
No, they're not in charge of the rules. They're here to determine whether the rules have been broken.
Oh, okay.
Okay?
Good enough.
Thank you.
Good luck. We were on number 6. 198000768-714 North Avenue. Nicole Lee, Gracie Ellsworth, and Noel Jones. Any of those folks are here?
We can go outside. You need to go outside in the lobby and talk, and she'll talk to you. Sorry about that. Nobody's here for that case.
All right, would city present their case, please?
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case 19-80000768. The address is 714 North Avenue. Property owners are listed as Nicole Lee, Gracie Ellsworth, Noel Jones. There's no prior cases with this owner. Exhibit number 1 going before the board are all my photographs. Exhibit number 2, notices to include notice of violation, notice of hearing. Exhibit number 3 is my administrative documents, including case summary, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return, receipt, as well as first class. And Madam Chairman, please accept these into the record as evidence.
Thank you, Bobby.
Yes, ma'am.
We have had only a phone call message returned with no contact with the actual property owner. This is on North Avenue. It's actually across the street from where the red Camaro car was parked. On October 25th, I noticed there were 2 vehicles with no tags on the property, and then there were 2 vehicles with dealer tags.
The dealer address, when I checked it in Sunbiz, was showing that address, 714 North Avenue, which is a residential address. The tags, Paul Henry 052 Zebra and Paul Henry 055 Zebra are both registered to West Coast Auto Credit and Auto Sales LLC at 714 North Avenue. I checked in the system. There's no local business tax receipt for the address for any business. The property is zoned residential and cannot be used as a car sales lot, parking lot, or operate the business as an address of convenience unless an LBTR, a local business tax receipt, is obtained. And then the storage of work-related vehicles cannot occur on the property. That's more or less what occurs, and they're kind of obviously doing that. On October 29th, 2019, the notice of violation was mailed as returned unclaimed. I conducted a reinspection on November 25th. There was no change. There was actually more vehicles now on the property with no tags. I had a violation on the property directly north of it. That property owner, he had violations in his backyard. He invited me into his backyard, and I noticed that there was vehicles tucked in behind the building that I couldn't see originally from the street. On November 25th, the notice of hearing was mailed. It was returned to us. On December 27th, I posted the property, and an affidavit of posting was signed. Conducted an inspection yesterday. There was no change. There's still numerous unregistered vehicles on the property. There's no local business tax receipt on file, and there again was 2 cars with dealer tags on them. The Sunbiz record was still showing that there was a business address at 714 North Avenue. The city code violations are 40.00, inoperable vehicles. Vehicles both need to be legally registered and operable. The lack of a local business tax receipt for operating a business within the city, and then also a violation of city code 25.03, which are the zoning requirements under R70, R60, 1 and 2 family residential zone districts, and not being allowed to have a car dealership parking lot. It's basically it's not an allowed use. I took more photographs. I think I actually took them from yesterday. And they were basically of one of the dealer tags, a couple of vehicles that were different from the original ones. Like I said, all of the evidence leads towards a car dealerships being run out of that property. With that being said, some of the cars that end up across the street
On her property
were related to this. I didn't add that to her case. She's taking care of it, and we're helping her out with that. But there's a significant number of vehicles down there on a daily basis. I would say anywhere between 8 to 10, and numerous different ones all the time. So that's all the city has at this point.
And they were not cited for the other debris in the yard?
I believe that's the neighbor's house. Yeah, they're like 0 property lines. So there's cars and debris. That was the neighbor that invited me onto his property, and I was dealing with his debris.
Just for the reminder.
I had a lot of calls on that block.
Anybody have questions for the officer? Summarize? You want to summarize, or is that pretty much it?
No summary. I have nothing further. Sorry.
I'm ready to entertain a motion, if anybody else is.
You ever finished looking at?
Okey-doke.
Did you say you were ready for a motion?
I am. They're just waiting to look through the package. You could start.
There's 412 pictures there, so it takes time.
I'm hurrying.
Okay, I can start it? Okay. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, sections 40.0011-3 and 25.03 of the Code of Ordinance of the City of Tarpon Springs was in force and effect. The respondents were in violation thereof.
Second.
Bobby?
Mrs. Telliar? Yes. Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
Part 2.
Like I said, this is pretty easy to solve. Oh, I'm sorry. Is it my turn?
Yep, go ahead.
Okay, sorry. This is pretty easy to solve. So basically, it's remove all the cars. I think 30 days is reasonable, and I think also the fact that this has kind of been ongoing for a while, another $100 a day is reasonable for that as well.
Only 100.
Well, that's just my recommendation.
Thank you. Do I have a board motion?
I move that the respondent shall have until February 10th to bring the property into compliance with code sections 40.00, 11-3, and 25.03, or suffer a fine of $100 per day for each day thereof the respondents remain in violation of said code sections.
I'll second that.
Abby?
Excuse me, Ms. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes. Yes.
Mr. Weeks?
Yes.
Mrs. Archer? Yes. Mrs. Wade?
Yes. We're going to take a 10-minute break and reconvene at 4:15.
Okay.
I'll be right back. Was it your note? Or his thing?
They're on there.
This,
To change them.
See, Mr. Tracy, it's good you came. We had
This world
the
is-
usual plethora of odd
everybody's
things.
playing a game.
It's all right.
Everybody doesn't
You did
want to
well.
cooperate. They don't want to do what they're supposed to do. They want to do something else.
He's so sick he can hardly sit.
These gals know better. These gals know better. They've been in the car business a long time.
My son
They don't have all those dealer plates
overtime.
unless you know what the hell you're doing.
I was hoping to be out here by 3. 'Cause I've got
They'll laugh. They won't think it's serious. They'll owe us $2,000, $3,000, $4,000 before they come back. On the other hand, the
It's not
attorney's
too
mad
much more
because
to
I
go
gave that guy $1 a day.
55-pound puppy.
I sort of like that.
But that poor guy,
I have to put it in a crate because I don't.
It's not well
I
behaved
didn't
yet.
have
well, this last guy with the ratty
my son
house,
leaves them out, but
I mean, I was gonna suggest, but I'm way off base.
in
Why doesn't he
training.
call the movie, the TV show
Yeah, we had to
Orders,
stop this-
and let them come down and
started
pay
back
him
in
to
August, and
shoot
now
it,
it
shoot
hasn't
the
passed
place.
away, and just haven't gotten back to it. Because it's so
That's
important
awful.
to get 'em to- I know.
Part of the problem and not
Yeah.
part of the solution.
Big of a dog
Yeah.
person, but I'm sure
My
he'd
brother,
hire
just
people
buried
that
my
have
brother
well-trained critters.
Well, my lady's a hoarder, but I'm a cleaner outer, so nothing hoards. I get rid of it.
The critters
Right,
like
and
it
this
too.
is-
They like
he-
to know why
he
children.
obviously
Yeah,
is,
that's expected. Exactly.
Going along with this behavior, he says he's argued with her, but he's probably,
Yeah.
as much involved in it now.
Well, if his brother, or whoever it was that was coming down,
It's mental health.
no, but I'm saying if they back up a dumpster, they can clean the house. Yep.
If there's an underlying mental health problem, trust me, years.
Hoarding is an insecurity disease.
Oh, no, it's part of obsessive compulsive disorder. It's an actual diagnosis. And it is impossible.
I'm cleaning
to
out and
fix.
throwing away. I have too much trash.
We don't conceive of it, but he has an infestation of roaches, and that girl with the wound is gonna go there. I think someone should be calling the nursing home and telling them that they need to do a home inspection.
Well, the nurse that comes in with her is going to say something.
I hope so. I hope so, Sonny. I hope so.
Are we having fun yet? Always. Today was a trip. There was some interesting stuff.
My brother's a detective in Philly. He's a homicide detective. He used to tell me. Now he's working homicide. But just some stuff he had.
Too early, started early to set out, because my mom didn't do the same. And that started now. So the next one, so the next one. Yeah, that might change, like you said.
His property had been condemned,
this is fun every month. This has been very interesting. There's been some interesting cases.
I just hear him say no rainwater. I
He said
missed
that
that.
sinks don't operate.
I missed that. I probably was looking at the pictures in a trance.
Yeah.
I don't know the plumbers, I just know on my street, they're putting two in right now, right next door.
Condemned houses, I took people out of their
Yeah,
houses.
it's, digging's expensive, and then it's 4-inch PVC, white's cheap. Labor to put it together is pretty
Where'd they
cheap.
go?
It's digging, and both these are open and done. I guess the city just hasn't got there to inspect it. But they did my neighborhood, well, my house was done when I bought it, and I've been there 10 years, so they did my neighborhood a while ago. These two houses have had financial troubles within the house ownership, and that never got done.
And they got used for churches.
Has to be done.
Not sure there's enough caffeine in there to do it.
No, it's water now.
I'm
Yeah,
glad
it's
mine's
filled up with
not.
water.
In fact, I had a motorhome and I used to clean out a curb for the motorhome, so I'm glad it was done. I don't have the motorhome anymore.
You know, you think that there might be savings
Let's
bonds
go in
or
the same
cash
place.
or whatever in those boxes, but you can't go through those boxes.
My brother-in-law's house, my niece and nephew's trying to
They couldn't tell.
Everybody understood it.
and anything of value is pretty much destroyed.
Even cash is not worth fighting for.
Yeah.
And I'm sorry for giving commentary on the one, but sometimes I can't stand it.
Okay, what's the word mean?
They charge
Invidious.
Do you have a parking lot with the new blue things?
That's what the lawyer said, that was invidious discrimination. It sounds negative, but I don't know what invidious means.
I don't either.
Pour some of this in. Oh, no, that's fine.
Invidious discrimination.
That's what the lawyer said, the first lawyer that spoke.
That was Herbilia, that doesn't count.
It means like chairs are full.
8, 9, 10.
Yeah.
I think everybody's back. We'll reconvene.
Okay.
I don't want him to hear me, but he's a terrible lawyer.
Still in the meeting.
Okay. I know him personally. Okay.
We're going to go down now to case number 7, which is 19-800000801, to be established, 503 Whispering Oak Drive, Greg LaDonna O'Brien, or Greg and LaDonna O'Brien. You're here for that? Thank you.
Oh, why'd they come in late?
Oh, she's got her puppy.
I'm not really sure, were you guys sworn in at the beginning of the meeting?
I think they made it in just in time.
Just in time? Thank you.
Puppy do it.
What's the dog's name? Did it get sworn in? And y'all, you're Greg and LaDonna?
We are.
And you're the owners?
I'm Greg.
Thank you. Do you have any objection to the city submitting their evidence?
We do not believe.
Thank you.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case before the board is 19-800000801. The property address is 503 Whispering Oak Drive. Greg and LaDonna O'Brien are the listed owners. Exhibit number 1 going before the board are all of my photographs. Exhibit number 2, all the notices to include notice of violation and notice of hearing. Exhibit number 3 is administrative documents, case summary, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return receipt requested, and first-class mail. And Madam Chairman, if you would please accept these into the record as evidence.
Thank you. Bobby?
Yes, ma'am.
So my case started on November 7th of 2019. There was a PT Cruiser on jack stands in the driveway. It was also blocking passage on the sidewalk. It creates a nuisance condition. City Code 8-38, he was cited under 8-40 and 40.00 at the time, but City Code 8-38, which supplies the definitions to 8-40, defines a nuisance, and I'll just summarize it really quick and get to the one. It says that conduct specified in the article in Chapter 4 of this code, any continuing condition or use of premise or of a building exteriors of land which, we'll go basically to the fourth one, which says essentially interferes with the comfortable enjoyment of life and property and tends to depreciate the value of the property. And then it also talks about unlawfully interferes with, obstructs, or tends to obstruct or renders dangerous for passage any public or private street, highway, sidewalk, stream, ditch, or drainage. This will become important as I present the rest of my case. On November 7th, a notice of violation was mailed. The green card was returned signed. On November 20th, I conducted a reinspection. The vehicle is still blocking the sidewalk. I didn't know if it was operable at the time. It hadn't moved, but it wasn't on jack stands anymore. On November 22nd, the notice of hearing was mailed. It was returned signed. On December 27th, I posted the property and signed the affidavit as such. On January 8th, I conducted a reinspection. It was still in compliance, but because I also had a situation where I cited one vehicle there, wrote a city parking ticket under Florida State Statute 316-1945, which says you can't park on a sidewalk, a few months back to one of the vehicles there. So now another vehicle is parked basically in the same place. I decided to bring it before the board so we don't have a continuing problem with this and basically get the property established for a violation of the two city codes, which is duty to maintain private property. As I stated, that's 8-40, which encompasses the nuisance condition of interfering or obstructs or tends to obstruct a sidewalk. And then 40.00, which is inoperable vehicles. Obviously, the fact that it's on jack stands and has a wheel chock behind it pretty much leads to the conclusion that at some point in time it was inoperable. So that's what's before the board. As I stated, it's currently in compliance. There is no violations when I inspected as of yesterday. I have the odd feeling that there probably will be, hopefully not in the future, and that's what this would prevent. So that's why we're here. And the city at this point has nothing further.
Do you have any, this is just the questions part, do you have questions for the officer? Then you get to present your case in a little bit.
I do not believe I have any questions at this time.
Your turn.
Okay.
Can you bring the mic in front of you?
Oh,
yeah, so we can all hear you.
I hear it fine.
Turn the whole thing.
Okay.
There you go, perfect.
Okay, generally, we concede on November 7th, yeah, the vehicle was up on jack stands. We had an incident with the vehicle. Belts had fallen off and jammed mechanisms. We had it up on jack stands. We were trying to repair it overnight, and we didn't get it done. We stopped doing anything at 9 o'clock, just as a respect for the neighbors. Trundling a jack back and forth is rather noisy. Bad judgment call on ours. We left it up on jack stand. It just happened to be unfortunate circumstances. The officer saw it up in there. We concede it was up there, and because it was on jack stand, it was considered inoperative. It did block the sidewalk. Again, that was the nature of beast. Trying to get the vehicle going. It was my only means of transportation at the time. Tried to get it together, couldn't get it together, couldn't get it off the jack stands to put back in a safe condition. Within a short period of time, we were able to get the vehicle back off the jack stands and move the vehicle over to the position to where the vehicle was in the center of the driveway. Now, I preclude this with, his statement was there was another vehicle that was in there. My wife's Tahoe was in the driveway. We had been notified, hey, you can't block the sidewalk. We had a couple email conversations back and forth with the officer. The last conversation was, hey, because she's handicapped, because we got a service dog, I have an autistic son, putting him into the vehicle out on the street just didn't seem to be acceptable. We asked, we're going to turn the vehicle, we're going to put it in the center of the driveway, and I work with rules and regulations from the FAA, and I understand there's the letter of the law and then there's the spirit of the law. The letter of the law says don't block the sidewalk. Spirit of the law says we don't block the sidewalk because we don't want people walking in the street. We don't want people walking in an unimproved area. We want them to walk where it's safe to walk. We felt that putting the vehicle there and notifying the officer, hey, we're going to do this, we're going to have a 4-foot clearance around there, which is wider than the sidewalk. We felt that that was the resolution to it, and that was back at the beginning. We had sent an email to the officer. We got no feedback from it. From that time up until the 7th of November, we had concluded that as long as we kept everything in there, there was no problem. The PT Cruiser, we conceded, it was just bad timing. It was a bad situation. That was our, my bad. We left it there. We remedied it, moved the vehicle over to the center of the driveway, believing that that was going to be the fix for it. Had no contact with the officer to give us any idea otherwise. Up until January 6th, we felt that that was the resolution, but then the officer posted it again, and it was like, okay, obviously there's some sort of problem. We went ahead and turned the vehicle so that it didn't block the driveway anymore. I called up the following, actually, we had an incident at the house, and we were trying to decide who was, there was an incident at the house, and we were trying to figure out what was going on. We had called code enforcement, asking questions if the inspector was in the area. She assured us that he wasn't. And at that time, I also talked to her about, hey, we still have this problem. And she went through and she checked with a few people there and says, no, you can't be on the sidewalk at all. And then she brought forth a comment on the status of it is, well, we did what we did, and that, okay, but now you're putting people walking into, basically trespassing onto our side of the property line. Hadn't considered that. Okay, we're good. We get that. So our resolution will be park the vehicle as the inspector had found it, and it also does help out to some extent with keeping the wife and the kids out of the street. We can concede to that until such time as we can remedy another problem, which is lack of parking in our driveway. So at this point, that's where I believe we're at. And then I will have some other questions for the officer for future things that we won't be taking up here. If I may, I'm a little hesitant on this, but based on previous appearances in here, when the first vehicle was cited, and this is just a noteworthy thing, neighborhood incident basically brought the officer to our neighborhood. Neighbors feuding, and we were collateral damage in it, and there was issues we needed to fix. When my wife's Tahoe was cited, unfortunately, directly across the street, neighbor's house, their vehicle was also in the driveway. And we're talking at the same time, and this is why I bring it up, because I noticed that you said, hey, it only has to be pertinent at that time. My son went out, took a picture of the Tahoe with the ticket in the window, with the neighbor's car in the background, and there was an inconsistency in there. He had to drive past it. We live in a cul-de-sac. He had to drive past it and not notice it to cite our vehicle. We're done with that, unless you have other questions, but I just wanted to bring that up.
Does the board have any questions for the owner? Does the city have questions?
I have none.
Summarize?
No, thank you.
Anything else?
I don't believe I do.
The board doesn't?
If I may, I do have copies of the pictures, although they're not the quality I think they should be, of the incident that I was talking about. And
Thank you. We'll close the public portion if we have someone that would like to make a motion.
We're just establishing, right?
We're just establishing.
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violations, section 8-40 and 40.00 of the Code of Ordinances of the City of Tarpon Springs were in full force and effect. At the time of the notice violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Bobby?
Yes. Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer? Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Mrs. Wade?
Yes.
Motion carried.
Yes, sir. You and your wife have been found in violation of sections 8-40 and 40.00. There is no fine established for today, nor is the city going to receive prosecution costs. But should the violations occur again within the next 5 years, you'll be deemed to be a repeat violator, and a fine will be instituted at a following Code Enforcement Board hearing. An order will be issued within the next 10 days. It'll be sent to you at the address listed at the property appraiser's records. If you have any questions as to what you need to do in the future, please contact Mr. Gass, and he'll be happy to answer your questions. Okay? Thank you.
Thanks for coming in. Item number 8, 19-800000820, 1642 Sea Breeze Drive, Andrew Beath.
No one present. Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case number 19-800000820. The property address is 1642 Seabreeze Drive. Listed as the owner, Andrew Beath. Exhibit number 1 are my photographs. Exhibit number 2, notice of violations, notice of hearing. Exhibit 3, administrative docs, case summary, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent return receipt as well as first class. And, Madam Chairman, please accept these exhibits into the record as evidence. Thank you.
Yes, ma'am.
We've had no contact with the owner. The case started November 18th. Initial inspection was that a fence was installed out front with no permit on file. I checked the Google Street View in January 2019. There was no fence there. So I took a picture, and there's now a fence there. Checked the city. There was no permit pulled for the fence that appeared sometime between January and when I took the pictures in November. On November 18th, the notice of violation was mailed. Green card was returned, signed by the property owner. On December 2nd, I conducted a reinspection. There were still no permits obtained, and the fence was still there. On December 3rd, the notice of hearing was mailed. It was returned unclaimed. On December 27th, I posted the property and signed the affidavit of posting. On January 3rd, permit number 20-12 was applied for. It hadn't been picked up, and it's also pending planning and zoning approval, so they have at least started the process. I conducted a final inspection yesterday. As stated, permit 20-12 was pulled, but it had not been signed off on, it hadn't been completed. And since this is an after-the-fact one, they won't be in compliance until either they remove the fence or the city actually says it's okay for them to have them. So kind of as we were discussing before, or actually I wasn't discussing, but Mr. Trask was saying, this is a building permit issue. So the thing about it is for a fence, in order for this one to be considered legal, you can come in and get a fence permit, basically drawing a site plan on a napkin, and they'll give you one. But for it to be approved, it has to be signed off and finalized. Once that occurs, then it's met the conditions of the city's requirements of obtaining that building permit and following through the whole process. So the violations before this board are violation 6-1, which allows me to adopt the 2017 version of the Florida Building Code. And then under the Florida Building Code, section 105.1, of our city code, requires you to obtain a permit to install a fence. So this would be an after-the-fact permit that they would need to obtain, or as I stated before, to be in compliance, remove the fence, and then start the whole process over again. Other than that, the city has nothing further.
I have a question. So somebody can violate the code and put in a fence, and there's no penalty?
I think they may charge them an after-the-fact fee, but I don't, that's the building department. I'm just here to cite them for it.
You have had no communication with him?
I have not, I don't think, nope, Beth neither has. And a lot of it is determining whether there's permits is by us looking in the database, and we could see a permit was pulled for the address. It's kind of like a paper inspection, although I did go out there and the fence was still there. So, but beyond that, I hadn't talked to anybody.
To have them come out and see this fence and approve it.
One of the buildings inspectors will have to, in this particular, especially in this case, they will have to sign off on it, because like I stated, they already have it installed, so they could put on a site plan something completely different, and then whammo, they got a building permit. But
what they actually did at the end of the day has to be signed off on. So,
Nobody else have any questions? We'll ask for a
I move based on the testimony, evidence, and facts presented and the law that at the time of the alleged violation, sections 6-1 of the 2017 Building Code and violation of City Code 105.1, permits required of the Code of Ordinances of the City of Tarpon Springs was in force and effect, and the respondent was in violation thereof.
Second.
call.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Carries.
Do you want number 9 to be established, or just made note that it's in compliance?
We need to finish this one, though.
Oh, sorry.
yeah,
We need to finish this one.
My brain
as
just
is the
hurt.
Compliance date and the dollar amount.
Okay.
Is 30 days a reasonable time period for this to occur?
I would think so, because they've gotten through at least the process where they've came in and applied for the permit. They just have to get through. Actually, 45 days might be more reasonable because planning and zoning is involved. And they only have hearings like once a month. So their next one, I think, is February 10th, something like that. So I think a little more than 30 days would probably be reasonable.
Okay. I move that the respondent shall have until February 28th to bring the property into compliance under Section City Code 6-1 and City Code 105.1, or suffer a fine of $25 per day thereafter if respondent remain in violation of said codes.
Bobby, roll call.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
So I don't need to summarize since there's no one here. No, I said I don't need to summarize for number 8 because no one is here.
Yes.
So as for number 9, it's complied. You're not moving forward in that case at all, right? You're just pulling it from the
Correct.
agenda. So
Yeah,
we don't
it's
need
in
to do
compliance.
anything on that one.
All righty.
Okay.
We did 11 and 12. Affidavits of noncompliance.
So there's no one here in the audience for this case or any others. The audience is empty, so we can just do a motion to accept the affidavit of noncompliance.
Voice vote, or we need to call?
You can do
roll?
it by a voice vote, but there needs to be a motion to approve, to accept the affidavit of noncompliance.
I move we accept the affidavit of noncompliance in case 19-800000691.
All in favor?
Aye.
Aye.
Aye. Opposed? Motion passes. Under the affidavits.
Oh, I forgot
There's
something. Let me back to that. I totally forgot.
You can do another motion to award the prosecution costs. if
I
you
forgot. You want to do another motion? All right, I move that we accept the prosecution costs of $142 in case number 19-800000691.
Second. Voice vote. All in favor?
Aye.
Aye. Opposed?
Okay.
Affidavits of compliance, and we can group those
Yes,
all
if you'd like
together. You need me to read out the numbers for each one?
Whoever's making the motion should do that, yes.
Okay.
I move we accept the affidavits of compliance in case number 16-800000375. And an affidavit of compliance in case number 17-800000538. And an affidavit of compliance in case 10-0200000096. And that's an old one. All in favor, say aye.
Favor say aye. Opposed?
Old business, none. Approve minutes, none.
Unless anybody has announcements or anything else they need to bring up?
On this, I would like to ask a question on, this is the public's, well, anyway, the people with, on the non-compliance on Martin Luther King Boulevard, they've been in here before in reference to their tree originally.
Which we abated, correct.
So when they came, why aren't they repeat violators?
Different ordinance. What happened with, the very first time, the tree case was, didn't come before this board because the city manager deemed it to be a life safety issue, so we were able to abate that tree and take care of it, and then we leaned the cost on the property owner. They had another case, but unfortunately, I was still kind of new, and there were other violations with that property, and then we received complaints about it. That's why we actually have 2 currently running cases on them for a myriad of different city code violations. And we are actually in the process of attempting to do something with that property that Mr. Trask will soon be finding out. So,
Our attorney's been here suffering all day with some kind of the cold or the flu, and I make a motion that he either goes home and goes to bed, or I take him out to the closest bar and get him drunk.
Meeting is adjourned.
Oh, just real quick before you smack the gavel, 1315 East Boyer, which was the one you commented on, that's really old. We demolished that house a couple of weeks ago. It was a property we started a foreclosure process on. The property owner chose to sign the property over deed in lieu to the city, and we demolished it about two weeks later. So that is now a vacant lot on East Boyer that the city owns. So it's, again, you guys' work in the process.
Yay.
Interestingly
Also saw
enough, it
that
was
the
a
one-
failure to connect to the sewer was his original case.
I also saw that the one on Gross is done, too.
The 127 North Gross is done. That was a significant one. And I believe, Mr. Trask, we've got a couple others that we're currently working on. Some
Good.
127 North Gross is he's still in the foreclosure process. We did an abatement because part of the building had actually fallen down. I think we can discuss that, right? The side of the building had actually fallen off, and it was a life safety issue. So we had to take some immediate steps to deal with that one, and it was demolished. But it is still
In foreclosure.
It's still in foreclosure. Yeah, we're still working on that aspect of it, so. So your work is appreciated, and it does go somewhere, so.
I have one question
Thank you.
for
We
you.
appreciate the feedback.
No problem.
Officer Gasson, can I ask you a question
Of
about
course.
the hoarding house that we saw, that property?
Uh-huh.
Yeah, the mic is still on, the meeting is still on,
Oh,
so.
you need-
Yes.
So let's finish your question, though, so the rest of the board can hear it, too.
My question is, does that property where there are life safety issues for a disabled person, does that get referred anywhere from our work? I mean, does anyone, you said there was a pest infestation of roaches.
Well, DCF was involved in that case.
Okay.
So there's kind of some tandem stuff going on. The advantage of me being a police officer is the officers will contact me for things that they just can't figure out. They'll go down their road contacting DCF and things like that and doing that. But then they're like, is there anything you can do? And that's how I get involved with these, and then ultimately you guys get involved with them as well.
I just feel so much better knowing that somebody's looking into
Yes, somebody is
that
definitely.
disabled person, yeah.
Yeah, but he said before you go.
Okay, so we will, once again, adjourn.
Thank you.
It's 4:37.
Sorry, Tom, you can go home.
And this was